Good morning, everybody. Happy Monday to you. Welcome to TCF Live. I am Dan Soul. I will guide you on this 3-hour journey through Courtlandia, starting in Allegan County, Michigan. This is Judge Skocelas.
Citation issued by the Allegan County Sheriff's Department on charges of operating while intoxicated and operating an uninsured motor vehicle. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Ms. Guyton for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. She is entering a plea of not guilty and does qualify for a court-appointed attorney. And we request that this matter be set for a pretrial and a jury trial, Your Honor. Thank you.
261760ST, the charge of operating while intoxicated, will enter a not guilty plea. Set this for a jury trial. Indicate you're requesting an attorney at public expense. Court file shows you released from the Allegan County Jail on a $500 personal recognizance bond. Bail will be continued in that amount. Condition of bail is that you not possess or consume any alcohol, marijuana, or illegal controlled substances while the case is pending. Case to be set first for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. Public defender has determined you are indigent. They will be appointing an attorney for you at public expense. On file 261759SM, the charge of operating an uninsured motor vehicle will also enter not guilty plea. Set this for a jury trial. Again, indicate you're requesting an attorney at public expense. Bail in this case was $500 personal recognizance. Bail will be continued in that amount. Condition of bail is that you not operate or allowed to be operated this 2011 Ford until valid insurance is purchased for that vehicle. This case will also be set for pretrial conference with the prosecutor's office and then for a jury trial in this courtroom, District Courtroom A. Again, the public defender's office has determined you are indigent and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss both of these cases with you at the dates and times of your pretrial conferences. The dates and times are going to be set to you by the clerk's office in the mail. So you are free to hang up from the court proceeding this morning. Be expecting those in the mail. Okay?
Thank you.
Have two files on Michael J.R. John Harris, 261535SM, 26SD44427SI. Both cases are based on the same citation issued by the Allegan County Sheriff's Department on charges of operating an uninsured motor vehicle and improper display of a license plate on that vehicle. We were here back on June 17th. At that time, Mr. Harris was told he needed to get fingerprints taken. Clerk's office adjourned this to today, July 13th. As of today, we still have no fingerprints on file. So, Mr. Harris, what happened?
On the 19th, at work, I had a grinder wheel explode on me, and I totally forgot. I had a bunch of 2 surgeries. I got 2 more to go. Messed up my eyesight.
Okay. Well, Mr. Harris, all you got to do is come to the courthouse to get fingerprinted. This is the second time now. I'm going to set this for a show cause hearing. You're going to come in person now. The show cause hearing is going to be set for an in-person date. When you come in, you'll get your fingerprints, and then we'll have those. If you get your fingerprints taken ahead of time, they will cancel that show cause. So it'll be up to you, but at the very least, we'll have a show cause date where you'll be here for your prints. If you do not appear for the show cause, a bench warrant will be issued for your arrest. Do you understand that?
Yes, I will have it done. Like I say, I was in the hospital for a week, and then a couple surgeries after that.
Okay. Well, are you physically able to get the fingerprints done?
I am physically. I can't see.
You can't see? Can someone else get to the courthouse?
That's my problem. I didn't have nobody else to get me there. So, but I'll figure it out. I'll take a bus, whatever I do.
Okay, so you will be able to get here.
Yep.
Okay. Well, indicate that to the clerk's office. Be looking in the mail for a date and time for the show cause. And again, if you come in and get those prints done, they'll cancel that show cause. Okay?
Okay. Thank you.
Thank you. Let's see.
Well, he's got a moment of silence. Good morning once again, everybody. It is TCF Live on a Monday morning. It is good to have you here. Let's make a pact right now that we're going to hit Monday in the nose and defeat it. Because too often we talk about how Monday's got a hold of us, and I think it's time to fight back, so let's do that. Also, while I've got you, do pay attention to the pinned chat. Do check out Court Watch at tcfcourtwatch.com. A more enhanced way to watch this show. You still get your YouTube feed, you still get your chat, but you get some extras. So do check that out. We made upgrades over the weekend. All right, back to Judge.
I have two files on People versus Todd Drew Haveman, 261756SM and 271755ST. Both of these cases are based on the same citation issued by the Allegan County Sheriff's Department on charges of operating an uninsured motor vehicle and operating that uninsured motor vehicle while his driver's license was suspended. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Haveman for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. And Mr. Haveman will be pleading guilty today, Your Honor. Thank you.
Both criminal charges?
Yes, Your Honor.
Mr. Haveman, is that what you've agreed to do, to plead guilty to both things you're charged with?
Yes, sir. Yes, sir.
First charge is a charge of driving an uninsured motor vehicle. That charge is a misdemeanor charge, carries a maximum penalty of a year in the county jail and a $500 fine. Did the public defender advise you of that?
Yeah.
Second charge is a charge of driving while your license was suspended. That charge is also a misdemeanor charge. That charge carries a maximum penalty of 93 days in jail and a $500 fine. In addition to what the court does, the Secretary of State's office will assess 2 additional points against your driving record. It looks like you're sitting at 6 right now, or 4 right now. This will put this up to 6. And they will also suspend your driving privileges for an additional period of time. Did the public defender advise you of that as well?
Yes, sir.
And knowing all that, do you still wish to plead guilty to that charge?
Yeah.
On June 20th of this year, you signed this advice of rights sheet. Before you did you read and understand all those rights?
Oh, yeah. Not really. I just signed it because I figure it's got to be done anyway.
If you plead guilty, you will not have a trial of any kind, and you'll be giving up all the following rights. First, the right to have a trial by a jury or a trial by a judge without a jury, and that would be at your choosing. You'd also have the right to have an attorney represent you on these cases. If you cannot afford one, you could request one at public expense. At a trial, if you had one, you would have the right to call witnesses to speak for you on your behalf. If you needed assistance to get your witnesses to court, I would order them to appear on your behalf. At a trial, if you had one, you would have the right to see, hear, and question all the witnesses that were called against you. You'd also have the right at a trial to testify yourself or to not testify and remain silent. If you chose not to testify at your trial, the prosecutor could not comment on that fact before the jury. Finally, if you had a trial in this case, you'd have the right to be presumed innocent until the prosecutor proved beyond a reasonable doubt that you were guilty of both of these charges. And sir, do you understand those rights that I've just read to you?
Yes, sir.
Those are your trial rights. If you plead guilty to both these charges, you will not have a trial of any kind, and you'll be giving up all those trial rights. Do you understand that?
Yeah.
Has anyone promised you anything regarding what your sentence will be if you do plead guilty today?
No,
Anyone threaten you to force you to do this?
no,
Is it your choice to plead guilty?
yeah,
And are you pleading guilty to both these charges because you believe you're guilty of both of these charges?
yes, sir.
And this case is based on a citation issued by the Allegheny County Sheriff's Department. It states on June 9th of this year at approximately 11:30 in the evening that you operated a motor vehicle on Western Avenue near Lincoln Road here in the city and county of Allegan. Were you operating a motor vehicle on that date and at that location?
Yes, sir.
On that day, was your driver's license suspended?
Yes,
And on that day, were you operating a 2006 Dodge?
yes,
And on that day, did you have valid Michigan insurance on that 2006 Dodge?
well, I wasn't aware that there wasn't any insurance, but yes.
Are you the owner of the vehicle?
No,
No? Okay. So someone else owned the vehicle?
yeah,
Okay. And you didn't verify before you drove it that there was any valid insurance on the vehicle?
yes, that was my mistake.
Okay. Based on that, I will find a factual basis. We'll find that your plea is knowing and voluntary. Your pleas will be accepted to driving while your license was suspended and operating a vehicle that was uninsured. Anything else you wish to tell me for sentencing?
No, you got all the information.
Looking at the materials in the court file, looks like your driving issues go back quite a ways, literally back to the last century. You lost your driver's license back mid-1990s for multiple drunk driving convictions. Since that time, have had a driving license suspended 2002 out of Ottawa District Court, 2021 out of this court, 2024 out of this court, 2025 out of this court, and March 3rd of 2026 out of this court. So your last conviction was the 26th conviction from March 3rd. And it looks like you made it an entire 3 months before you were stopped again. So it looks like, Mr. Haven, you just keep driving and driving and driving and driving and haven't had a license to do so since the mid-90s. On the charge of operating an uninsured motor vehicle, will impose a sentence of fines and costs only. On that charge, the fine is $500. Court costs are $300. State costs and fees are $125 for a total of $925. We'll put that out for payment over the next 90 days. The charge of driving while your license was suspended, there is a presumption that you not receive any jail, but it looks like on every one of these prior cases over and over and over again, you've just been given a sentence of fines and costs, and that hasn't precluded you from driving again. At this point, I'm going to waive the fines and costs, impose a state cost of $50, crime victim right fee of $75 for a total of $125, which is not waivable. We'll put that out for payment over the next 90 days. For the reasons as just stated on the record, we'll impose a jail term of 3 days in the Allegheny County Jail. You will need to report to the Allegheny County Jail next Friday, which is going to be July 24th by 7 p.m. in the evening, or at that time, a bench warrant would be issued for your arrest. All of the fines and costs on both of these files, you will have up to 90 days to pay. And again, the Secretary of State's office will assess 2 additional points against your driving record and suspend you out again for your most recent driving while license suspension. So with that, sir, you are all set today. You do need to report to the jail next Friday, 7 o'clock in the evening. Good luck to you, sir.
All right, thank you. Bye.
Two files on Brian Michael Schmidt, file 260403FY and 261791ST. The first file is based on a
Well, be that way, Judge, and just cut your feed right in the middle. Good morning, everybody. It is TCF Live on a Monday. Judge is trying to mess with me. I'm not going to let him. I was actually just typing in the chat that the real question is, will Mr. Haveman report for jail a week from this coming Friday? I'm betting no, but we'll see. Let's do this. Let's go to, let's head east over to the thumb. Judge Prill.
People of the State of Michigan versus Charles F. Martin, file number 267473H. This is time and date set for arraignment. Mr. Martin is present, represented by Attorney Dallas L. Rooney. People are represented by prosecuting attorney J. Cousins. Mr. Rooney, have you received a copy of the information that was filed in this case? Have you and your client had the opportunity to review it to wait for reading? Yes, all your. And I believe there's a plea offer here, correct, sir? There is. Mr. Martin, as best you can, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Mr. Rakowski, good morning. Would you please tell me the terms of the plea offer?
Yes, Your Honor. So the terms of the offer are that Mr. Martin would be pleading guilty to the charge, or excuse me, no contest to the charge. And with that, people agree to a 1-year delay of sentence. Part of that plea is that Mr. Martin is to pay, I believe it is half of the restitution towards that end within the next couple of weeks. The remaining amount of restitution will be paid during the portion of the delay. If Mr. Martin successfully completes the delay of sentence, conviction would enter as embezzlement 200 to 1,000. Mr. Martin also agrees to revoke his bond for 30 days during this time frame. However, he is serving time, and Mr. Rooney and I have talked. He's almost, I think, to his 30 days now.
All right. Mr. Rooney, is that your understanding of the plea offer?
Almost. He's going to pay 1/3 of that restitution between
That's
now,
a third.
and I think he's going to have for the sentence.
Yes.
Okay.
But other than that, yes.
All right. Mr. Martin, your name is Charles Martin, correct, sir? And you heard the terms of the plea offer?
Yes, sir.
Is that your understanding of the offer?
Yes.
Do you wish to accept it?
Yes.
Are there any other terms to the offer, bless you, that we have not covered on this record?
No, sir.
Mr. Rooney, do you agree?
I
Mr. Rakowski?
Yes, sir.
Mr. Martin, are you on any term of probation or parole? Have you had sufficient time to speak to Mr. Rooney about this?
I spoke with him this morning.
Okay, do you need additional time?
I don't think so.
I want to make sure. If you need time to speak with him, please let me know, because I don't want you to come back later and say, well, gee, I didn't have time to speak with my attorney. All right, so you've had sufficient time to speak with him. Mr. Martin, is there anything affecting your mind or brain making it difficult to make important decisions? You have a clear mind. In the information, you are charged with embezzlement as an agent or trustee, $1,000 more or less than $20,000. That is a felony carrying a maximum prison sentence of 5 years and or a fine of up to $10,000 or 3 times the amount embezzled, whichever is greater. Do you understand the charge and maximum sentence can be imposed?
Yes, sir.
Understanding that, then, Mr. Rooney, how does your client plead to the charge of embezzlement on or about March 1st of this year in Seaweed Township, Huron County, Michigan?
He pleads no contest. The basis is civil.
There's no contest to your plea.
Yes, sir.
Mr. Rakowski, any objection to the no contest?
No objection.
And you may proceed with getting that. All right, that is a proper basis to proceed. The court is in receipt of an advice of rights form, and it's actually dated today with a signature on it. And Charles Fred Martin is printed. Mr. Martin, did you sign this document first, sir? Sir, and before you signed it, though, did you go over it with Mr. Rooney?
Yes, sir.
And do you understand the rights contained on the form?
Yes, sir.
You understand that by pleading no contest, you're giving up those rights.
Sir.
You will not have a trial of any kind or have any opportunity whatsoever to contest your guilt. A no contest plea is tantamount to you admitting your guilt, and all that remains after today will be for you to sentence. If your plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to the court during this plea. You'll also be giving up any claim this plea is not of your own free choice. Other than the terms of the plea offer outlined on the record by Mr. Revokes, has anyone promised you anything such as leniency? Contest. You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. Yes, sir. As a court, have you been told the court will be easy on you? No, sir. Does anyone threaten you to enter this plea? No, sir. But your own free choice? Yes, sir. Court costs are due and payable at time of sentencing unless there's good cause shown. Are you aware of that, sir? Yes, sir. And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence. Yes, sir. Finally, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right. Do you understand those rights? Yes, sir. Again, I will ask you any questions of Mr. Root. Yes, sir. All right. Court is in receipt of People's Proposed Exhibit Number 1. Any objection to the court consider this for a factual basis? No, Your Honor. All right. People's 1 is accepted and the court will review it. Mr. Revokes, you have any promises, threats, or inducements for this plea other than what's been discussed?
No, Your Honor.
Mr. Root?
No, Your Honor.
Has the court complied with the court rule concerning pleas, Mr. Revokes?
It has, Your Honor.
Mr. Root?
I agree.
Mr. Martin, there's no agreement made by this court concerning the plea and what the final sentence will be. Is that accurate? Mr. Root?
I agree.
Yes, Your Honor.
Court will accept the plea. It's done freely, it's voluntary and understanding. A sufficient factual basis has been provided by review of People's Exhibit Number 1, which indicates that the defendant was an employee of a business trusted with money, and that he was in a position of authority over that money, and that money had been taken over a period of time, and the total was in excess of $1,000. As a result, the court finds essential elements to the offense been established. The sentencing date, please. September 14th. Mr. Rooney? Okay. Sentencing September 14, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report. Be prepared, provided both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing. Provided to counsel, any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing. Mr. Martin must appear in the court at the time of sentencing. If there's any supporting documentation, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was previously set at $8,000, 10%. It's not been posted. Mr. Rooney, your position on bond.
We're asking that it be converted to a PR bond. It's done more than 30 days since he has been in jail. That was what Mr. Revokes and I
Mr. Revokes, your position.
We have no objection to that happening, Your Honor.
Well, plea has been entered, the court has accepted the plea, so with that understanding, the court will modify the bond to $8,000 personal recognizance, same conditions. All we're doing is changing the monetary value, but otherwise all conditions apply. And Mr. Martin, just to let you know, for sentencing, you'll be meeting with Mr. Lick's office to get us a date for you to meet the probation officer, show up on time, meet with them, follow through, so the report can be prepared to see on September 14th. That'll be all. Thank you. Thank you. Mr.
Happy Monday once again, everybody. It is TCF Live. Few courts starting to get in action now. Let's stay in Michigan, but let's go up to Judge Elmore in Wexford County. We'll say good morning to him.
What do we do to help get Mr. Mosher here?
I can make a phone call and see if they'll just transport him up here.
Yeah, if you would do that, please.
Yeah.
All right, so Mr. Mosher, can you see and hear us? Well, maybe hear us, because I don't know if you can see because your hair hangs in front of your face. Right? Reminds me of that, was it Bugs Bunny cartoon? With
Yeah,
crows
the sheepdog.
The sheepdog. Yeah, I don't, Mr. Mosher, you're way too young for that. Do you even know who Bugs Bunny is? All right, he does. All right, well, that's good. That's good. Well, anyways, Mr. Mosher, we're going to see what we can do to get you over here. Mr. Harrison would like you, would enjoy the benefit of your company here at the table. So we're going to skip over you, which is because the deputy's going to see what he can do to get you over here, okay? All right, and I see, oh, there she is, everybody. Corrections Officer Kunkel. Everyone put your hands together.
She's a rock star.
All right. Nope, your volume's not on though, unless you're lip syncing.
Can you hear me?
I can hear you now.
Okay. I stopped the officer before he left the Sally Port, so I'm gonna get him chained up and sent up. Okay? Right.
The officer chained up or Mr. Mosher?
Look at him.
Okay.
I mean.
Okay. Hey, I'm not here to tell you guys how to do your job. All right, thank you. Well then, as we're going to move beyond that one, welcome here to the 28th Circuit Court in Wexford County. We're going to jump on to number 2 today. Number 2 is going to be People of the State of Michigan versus Teresa Evans. This file number is 26-14214FH. We're here today for sentencing on this case after a plea was entered back on May 22nd of this year. Appearances from counsel, please.
Isabel for people. Thank you, Honor Taylor and Andy Devanto on behalf of Ms. Evans, who joins me at council table.
Thank you. Also here this morning is Mr. Kevin Stone, from the Michigan Department of Corrections, who is stepping in today for Mr. Brian Potter. Mr. Brian Potter's agent prepared today's pre-sentence investigation report. Now, I also see that CFJ 145, page 1, it says the illustrious Jeffrey D. Harrison represented Ms. Evans, but now we've got Ms. Fioraventos. Let's go ahead and make sure we get that changed. All right, let me take a look here to see if I noted any need for correction. Okay, I did not catch any corrections. Let's see if anybody else did. Ms. Dalton?
None from the people, Your Honor.
All right, now we're down to the defense.
Making so much my one page reason.
Sure.
No, Your Honor, I did provide my client with a copy of the pre-sentence investigation report this morning. She reviewed it. She did not catch any corrections or additions. I did not catch any either myself.
All right. So let's go ahead and jump on to allocution then. Let's go with Ms. Gervin.
Thank you, Your Honor. My office also has provided, I do apologize, as a person where I was out last week for trial. In that time, I had asked for the submission of some proof that my client had completed rehab programs and had voluntarily attended services.
Sure, if you got a copy for me and a copy from Ms. Dahl, let's go ahead and provide them. If not, just show Ms. Dahl and I'll take the one, that she hasn't got.
I have already provided copies to Ms. Dahl. I also have a letter from my client just gave me this morning from her general manager at her job.
Okay.
If I may approach.
You may.
And the court can keep these copies. I have additions and the copies have been provided to the prosecutor as well.
All right, thank you. I have those now in my possession. Let's take a quick look here. All right, I've taken a look at the letter from the employer, and I've also reviewed the attendance records provided by that's okay, thank you. Allocution, Ms. Ferravento.
Thank you, Your Honor. I do apologize. I did find, I believe, an error in the evaluation plan. CFJ.
Go ahead, sorry.
CFJ 284A, page 1. You're looking at that fourth paragraph. It is my understanding the client in the probation violation that came from these same events over in Missaukee County pled no contest, not guilty.
Oh, all right.
And I do apologize. I just want to make sure that's correct.
Okay.
And the reason for that no contest plea was the possibility of this case over here.
I got it.
So I did want to just make sure that was corrected.
Sure, we'll go ahead and make that change. You got it, Mr. Stubble?
Got it, yes, you.
Fantastic. All right, back
Thank
to
you.
allocution. Yes, ma'am.
Thank you, Your Honor. I would like to start off by giving a bit of a timeline to the court. The events leading to this charge occurred back in the summer of 25. My client was then violated on her probation and served a sentence related to that back in 2025. She ended up getting additional 12-month probation in her Missaukee County case and then served 210 days of jail over in her Missaukee County case. February of this year, 26, that is when this charge came through, again, from the same underlying events. She ended up entering a plea. She ended up entering a plea with Mr. Harrison at our last proceeding. We thank the prosecutor for that generous offer. Now, between the time of these events occurring and getting to us here today, Ms. Evans has secured employment, and we've presented that letter from her manager. She has completed multiple voluntary rehab programs as well as court-ordered programs. She has provided certificates of completion for those, as well as voluntary compliance with Catholic Human Services while in the Missaukee jail. Thank you. And she's informed me that she continues with Catholic Human Services. Now, we understand the court's normal position. If you mess up probation, the court is hesitant to give another opportunity. But we're in a bit of a unique situation here, Your Honor, because yes, while there was the probation, you mess up probation on a prior case, the court's less willing to give another opportunity in the future. However, in this particular situation, because of the way the timeline worked out, she was given that other opportunity at probation last year. She has been doing well. She has shown her progress and commitment. And we would just respect the request, Your Honor, that the court allow her to continue with her probation or continue with probation in this file as well. Again, considering that she has been doing so well, I would also note we've had no violations that I'm aware of or minimal issues since she's been on bond back in February. She's taking those steps. She's made good progress. And if this was a normal circumstance that this is coming about, this is being charged immediately after occurrence, I could understand the court being more hesitant to give probation. But considering this wasn't charged until, again, after she'd already completed a sentence in the Misaki file, resume probation and had been making good efforts, we would just ask that the court allow her to keep that momentum going, and the court order probation. She's open to however much probation the court thinks is necessary to ensure that she remains sober going forward. Thank you.
Thank you. Ms. Dahl, on behalf of the people, ma'am.
Thank you, Your Honor. I believe the recommendation is appropriate based on her actions since the event occurred. She was on probation. She was violated already for the same conduct and seems to have taken it seriously since then. I don't know any bond violations. I do know that in her prior offenses, her prior cases, she was able to be successful on probation. And I believe the longer term of probation that is requested of 36 months is appropriate considering her past with substances. So I ask the court to follow the recommendation. Thank you.
All right, thank you. All right, Ms. Evans, it's your opportunity now to make a statement if you choose to do so.
She's not up.
Okay.
Thank you.
All right. Well, I will take a little bit of some sensitivity with statements from the general manager. He talks about the word trustworthiness. Well, the challenge that I have there is you have a long history of stealing. So those are crimes of dishonesty. Let's see, I counted 8 theft cases. Larcenies and retail frauds have been, especially retail fraud has been your #1 go-to criminal activity. Then here you were on probation, and then you had a couple of these drug cases. Now you're in a position where you've got an intermediate straddle cell. Had you been even just pled to a possession, if that was the agreement for the offer made by the prosecutor, it would have been a 5 to 23 sentencing range. So they have definitely saved you by saying, well, even though we've got a possession case, we're going to reduce it down to a use case. I don't know if they look at guidelines before they make those, but I'm going to say they've saved you because now it is a 0 to 17. It went from a class D felony to a class G felony. One second. Huh. This wasn't merely it's not a large amount, but 6 grams, digital scale, and then the small jar of the methamphetamine. It had some, some methamphetamine residue. I don't know, but that's okay. So we had also could have been a second or subsequent or habitual offender third. So therefore, on an original possession of methamphetamine, it could have been not just the 5 to 23, but the 5 to 34. And the max could have gone from 10 up to 20 years, and they made it a 2-year level case. So you got a significant benefit. And for the moment, you've been using marijuana since you were 19? Since you were 19, that doesn't seem to be working out well. And you've been using methamphetamine and or opiates over the last 5 years at the very least, I should say. It goes from 2020 until 2025. So at least 5 years, and although we don't have any testings for positive, that's going on since she was released. What was the date she was released from the jail? Can you tell that, Mr. Stapleton? I know she had 210 days. Maybe I can do some math here by myself. So the other case in Missaukee County occurred on January 20th of 2025. She was placed on probation, sentenced on May 16th. And she was violating probation here within less than 4 months, so 3.5 months. She got 210 days in jail. She only had 30 days in jail. Hold on. All right. When did you get out of jail?
Now it was February 13th.
So she wasn't arrested on this until February 2026. When was the case filed? Actually, the charges were filed on January 30th and arrested on February 4th. So it looks like, Mr. Stapleton, you guys have the wrong arrest date, because at least according to the court file, it was February 4th, 2026. Couldn't have been looks like she even had an arraignment. Let's find that out. Looks like the arraignment was done on the 20th. Now somebody's got something wrong here. No, because she had a PR bond on February 5th. So what I'm telling you is on CFJ 284 Alpha, page 8. At the bottom, arrest date should be February 4th, not February 24th.
Then just to clear things up, 145, page 2, CFA 145, page 2, that jail credit dates would be incorrect also. So
yeah, they should be. Looks like it should be She was given a PR bond. She was arrested on the 4th, then arraigned on the 5th, and then posted on the 6th. I think that would be 3 days credit.
Yes, that would be, sounds correct. Yes.
Thank you. Correct that as well. All right. So the defendant's prior criminal history began in 1997, but that one was old. And then she got to 2006, and then from there on, that first one was dismissed. So now we jump to 2008. We get a retail fraud. She makes it 5 months after that case before picking up more retail frauds. She makes it about 6 months and picks up another one. This was a medical or Medicaid fraud case in 2009, carrying it to 2010. Mr. Stapleton, looks like in CFJ 284A, page 5. Look at entry 6 of 13. You'll see that that should say on probation, because she was sentenced to 18 months of probation on April 16th, 2010, and wasn't discharged until July 25th, which would have been 6 weeks after that event. So she violated probation then again. How she got a successful one, I don't know, but it doesn't make any sense there. Now, if you look at entry number 7 of 13, again with an offense date of June 6th of 2011, but again, not off of probation until 6 weeks later. Number 7 of 13 means that she was on probation. Somehow she was given a successful completion. Well, in that case, she had multiple retail frauds. All right. Well, it looks like 8 of 13 is probably correct, but I think she would have been on, hold on, let me check. All right, because she didn't get arrested on 6 or 7. All right, so yeah, she wasn't on bond for any of those other cases. All right, keep going. So we get another set of retail frauds in 2011. Then we get some other disturbing the peace here in 2016, 2020 back to stealing, 2022 back to stealing. In fact, still apparently some balance on that one. And then she made it about a little less than 2 years, picked up the meth case over in Missaukee County, and she violates probation within just a couple months. And the prosecutors here reduce it from a potential 20-year with more than likely a prison sentence down to an intermediate sanctioned cell 2-year offense. Which is their prerogative, that's fine. So now what does this court do? All right, well, she has been doing well on bond. That's great. Ms. Evans, I know you pointed to your counsel and said, well, she said it all, but she didn't. Not that you did a bad job. I'm just saying, what's different? I mean, this is nothing but stealing and what's...
Stealing's behind me for sure. I just want this to be behind me, and I know that I'm willing now. Before I had to do it, now I want to do it.
What are you learning in your treatment program, Catholic Human Services? Tell me about it.
I know it's bad. I just know the drugs bad and it's not, there's no good to it at all. And then I realized that.
Well, you're in AA or I'm sorry, NA. What step are you on?
I'm not doing stuff yet.
No?
No.
All right, what are you doing in NA?
I'm just doing a group, I do groups. Do a group with Catholic Human Services and then one-on-one. And then I go to the NA like Jacob's Well or Fentanyl.
Okay.
Meeting. I at least do 1 week with them. I've been working a lot.
All right.
I'm just willing to do it now. I don't want to have to worry to do with it. I know it's wrong, bad. I just want to learn to do it. I'm going to continue to do, even if I don't have to, I'm going to still continue to do the NA.
All right. Well, now you don't, not everyone has to do a 12-step program. I know they don't work for everyone. A little surprised there.
I do have a peer recovery coach now.
Okay.
2 of them actually. I do with Nikki and with Mark.
All right. Well, this is what's really it's kind of concerning. I know for some judges they believe they can do a hold sentences in advance. I don't see where there's any legal authority for courts to do that. Then I've got the legislature that tells me I'm supposed to use probation when I think the person's not likely to reoffend. So we've got a pattern of reoffending. I also have the legislature telling me that a 0 to 17 means a presumption of 0, unless I have reasonable grounds. Definitely think there are reasonable grounds because you keep violating probation and committing the same offenses while this one is just a second back-to-back drug case. But I'll tell you, this was 6 grams in scales. You're lucky there weren't any extra baggies. I don't know. But you've been doing all right with this, but with this meaning the conditions, but that's what someone is supposed to be doing. So, and I'm having a hard time figuring out why. Why should I not put you back into the jail? Because I have I do not agree, as everyone knows, that drugs are a victimless crime. That is absolutely ridiculous to say out loud. And they are killing the community. Every time I hang out or talk with anybody, hey, what kind of cases are you doing? Meth. It's the same thing. Methamphetamine. Everybody's doing it. It's coming in. It never seems to stop. And people are getting caught with more and more every year. Every month, it seems like. And here you were on probation, driving a car that had no insurance, that allegedly you were in the middle of purchasing. But you can't purchase a vehicle and drive it unless you know there's insurance. So, and then you blamed it here and it said, the defendant called the owner who stated that there was no insurance, with the defendant asking the owner to put insurance on the vehicle. You're the one buying the vehicle. I don't buy that.
Well, I was supposed to, she's supposed to keep the insurance and the plate on it until it's purchased all the way.
Okay. All right. Well, I don't know. I don't know necessarily what to do. Then there's also the fact that you had the probation violation over there, and you got 210 days in relationship to the same charge, and then had somebody adjourn that other case, waited for this case to catch up. Then you would have probably gotten equal time or time served. So to me, this seems to be somehow it's gotten up here in a very low way. 3 months to get the lab's test done, which I'm not blaming the prosecutor, that's the lab. By the time they got done, we got charges right when you got off of the probation violation. Mr. Stapleton, do you know, can you confirm that, or maybe you don't know, that probation violation over in Missaukee County was only this?
I honestly can't.
Okay, no idea, no problem. All right. Well, I gave you 210 days over there. So I wish I could hold it in advance. I don't hold some kind of term in advance over you. But so here's what the court's going to do. I'm going to place you on probation for 36 months, 3 days in jail with 3 days of jail credit. The court adopts the terms and conditions listed for probation that are contained in the PSI and CFJ 145 pages 2 and 3. Please know that the phrase other intoxicants that says you are not to use or possess, that includes marijuana. So, all right, 46 years of age. The only reason they're not going to prison is because they cut this deal from a 20-year down to a 2-year. Technically, it went from a felony to a misdemeanor. It's only a felony because of the habitual enhancement. Yeah, the second, was it a second sub? No, it says a second felony. It doesn't make sense. Is it a second felony or should that be a second subsequent? Because if you can't have a second, you can't have a misdemeanor unless you are doing a second subsequent. So I'm wondering if CFJ 145 is correct. All right, so see at the top where you said, or not you, but Mr. Potter said controlled second sub. What I'm trying to tell you is underneath the phrase plea agreement, it says second felony. I think that's, and it says use second, but I think that needs to be cleared up. It should say second subsequent.
Okay,
Got it? That's it. So it's just a small change.
yes.
All right, thank you. You have the right to be considered for early release as long as you're compliant with the terms and conditions of your probation at halftime. If you're not, then your probation will continue. That includes the payment of fines and costs. Wait, do I do a 56?
You didn't do anything.
Do I do a, yeah, it's $68 with a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost for the processing of this case. And the court's going to assess a $500 fine, a $300 attorney fee, no DNA, felony, and a supervision. I'm sorry, there's already DNA was available. $30 supervision, unless there's electronic monitoring, then it's $600. All right, did I miss anything, Mr. Stapleton?
I don't believe so, no.
All right, Ms. Dole?
No, Your Honor.
All right. All right, Ms. Fioravento is going to bring you 2 copies of one document. You're going to place your initials on the first copy. Both copies say exactly the same thing. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal, as you want the court to appoint an attorney to assist you, you may complete the bottom half and return to the court within 14 days. If you choose not to appeal, you may simply dispose of your copy of the document. All right. You may, all fines and costs to do within the first 56 days or a 20% penalty will be added. As long as you make your payments by the end of your probationary period, the court will waive that 20% penalty. You understand? Ms. Evans? The only reason you're not going to prison is because of them, the prosecutor's office. All right, thank you very much. We're adjourned.
Yeah.
Alrighty, friends, TCF Live. It is Monday. It is good to have you all here. If you haven't yet said good morning to us in the chat, please do take a moment and say good morning. We're a friendly folk here. You'll find us welcoming. Let's do this. I want to go to the 55th District Court. This is Magistrate Stephanie Godsey. This was a few minutes ago, and as I was paging through, it sounded like some fairly serious allegations / charges against this defendant. I don't quite know what's going on, but let's see.
Michigan versus Hunter Scott Ball, BALL. This is case number 2601044FY. We have Mr. Ball, who appears before the 55th District Court via video conference from the Ingham County Jail. Mr. Ball, can you hear me okay?
Yeah.
All right. Mr. Kaplan, good morning. Your appearance, please.
Good morning, Magistrate. Jeffrey Kaplan, P74943. On behalf of the defendant, we are both appearing by Zoom.
Thank you, Mr. Kaplan. All right, Mr. Ball, our court has before it a felony criminal complaint that's been filed against you by the Ingham County Prosecuting Attorney's Office. This criminal complaint alleges that on or about June 7th of this year, 2026, through and including July 4th of 2026, at a location described as 4033 Eastbridge Circle, Village of Stockbridge, County of Ingham, State of Michigan. Allegations and count.
Go ahead, ma'am. Go ahead. I'm sorry.
The allegations in count one are that the defendant did engage in a willful course of conduct involving repeated or continuing harassment of Mary Jeanette Robinson, the conduct being such that would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, harassed, and or molested, and that such conduct actually caused Mary Robinson to feel terrorized, frightened, intimidated, threatened, harassed, and or molested, and that the defendant has previously been convicted of MCL 750.411H, this is referred to as aggravated stalking. So basically it's aggravated stalking because the defendant has previously been convicted of stalking, and it is a felony that's punishable by up to 5 years in prison and or $10,000 fine. Also, you could be placed on probation for any term of years, not less than 5. Count 2 alleges that the defendant did use a computer to communicate with Mary Jeanette Robinson for the purpose of committing aggravated stalking. There's a SORA notice involved. This is a Tier 2 offense under the Sex Offender Registration Act. If the underlying offense is a violation of MCL 750.145 or 0.520G, it is a Tier 3 offense if the defendant has a prior conviction for a Tier 2 offense. And it is also a felony offense that's punishable by up to 10 years in prison and or $5,000 fine, and reimbursement of government for expenses incurred in relation to the violation in the matter indicated by state law. Also, a consecutive sentence may be imposed for a conviction on the underlying offense. To understand the charges the court's read to you, Mr. Ball, and the maximum possible penalties?
Yeah.
Mr. Kaplan, are you demanding exam?
We are, Your Honor.
And is he applying for your office?
He is.
Okay, I've made those notes in the file. This case is assigned to the Honorable Judge Hillman. It's scheduled for a probable cause conference on Tuesday, July 21st at 8:30 in the morning. And then a preliminary examination on Tuesday, July 28th at 9:30 in the morning. With that, Mr. Kaplan, on bond, I should tell you that there is already a bond recommendation. There has been a bond recommendation filed by the prosecuting attorney's office, which of course is the court reviews it, but is not bound by that recommendation, as you know. They allege that there's a history of violent behavior toward the complaining witness in this case, history of threatening and or harassing behavior toward victim or witnesses. They, other factors associated with lethality. They cite and allege stalking behavior, acute depression, or unpredictable and violent mood swings. They also provide a little bit of background where they say the defendant has a prior aggravated stalking case with the complaining witness in this case, Harley Robinson, where, of course, as you and I spoke about off the record, he was found not restorable after a competency evaluation. They note that he was warned at the last hearing that there was still a personal protection order in place, and that he was to have no contact with Harley Robinson. They allege that only 5 days after being released from the jail, he made contact and direct threats. I won't get into all the other allegations. He does also have a probate and mental health order out of Sanilac County. And so with all of that background, they're asking for a very high cash or surety bond. And with that, I'll turn it over to you, Mr. Kaplan.
Certainly, Your Honor. I will note my client's 27 years old. He is living with his parents at that Snover Road address. That's what he informs me. I don't know about the previous convictions or the charges that he previously faced. I don't know what the communications are in this case, but I will note that the charges don't involve any violent contact, just apparently computer contact. Considering that he lives with his parents, Your Honor, and he is indigent, he's unemployed right now. We would ask for a low cash bond, $5,000, 10%, or 500 cash.
Thank you, Mr. Kaplan. All right, we're going to start by going over some of the bond conditions. And Mr. Ball, if you do post bond, you'll get a copy of your bond conditions as well as your notice to appear. You are required to report to Ingham County pretrial services if you're released from custody while this case is pending. That's a phone call. You must call that agency within 2 business days of being released from the jail. That's the agency that would supervise you while you're out on bond. Failure to contact them within 2 business days of your release would likely result in a bench warrant for your arrest. You are not to purchase, possess, or consume any alcohol, no illegal drugs. You're subject to random drug and alcohol testing. You are absolutely prohibited from purchasing or possessing any dangerous weapons of any kind. No knives, no guns, no ammunition. You're not to engage in any assaultive, harassing, threatening, intimidating, stalking behavior toward anybody with whom you've ever been married, with whom you share a child in common, any current or former resident of your home. Those conditions also apply specifically to both Harley and Mary Robinson. And I'm going to try to be just as clear as I can right now. You are to have no contact, direct or indirect, with Harley Robinson or Mary Robinson.
Okay.
No phone calls, no jail phone calls, not in person, not in writing, no social media, texting, emailing. You are also prohibited from trying to have somebody else get a message to either of those 2 persons. If you can dream up in your mind a way to get either one of those persons' attention, don't do it. It will be a violation of the no contact order. And if you're not in jail, you'll be immediately rearrested. If there are allegations before our court, credible allegations that you're attempting to make contact while you are incarcerated through any jail communication privileges, the next likely step will be to revoke all of your jail communication privileges, all of them except for attorney-client. Do you understand?
Yeah.
Okay. You are prohibited from appearing on any property where Harley Robinson or Mary Robinson are known to live, work, attend school. Any of those known locations, you cannot be there. the court is also ordering that in order to be released, he must have a GPS tether, Mr. Kaplan, with a 2,000-foot exclusion zone. So in order to get out of the jail, one of the conditions is a GPS tether where you cannot be within 2,000 feet of Harley Robinson, Mary Robinson, or anywhere that they live, work, or attend school.
Okay.
With regard to bond, the court is required, as you know, Mr. Kaplan, to assess both flight risk and public safety. There's not a lot on the record to indicate flight risk that Mr. Ball has not appeared at court. However, the public safety concern is practically off the charts at this point. With the history, documented history of behavior, the documented history of a complete lack of impulse control, not being able to stay away, not following the rules. And there is an obligation to the public, and specifically the complaining witnesses in this case, to ensure their safety. And for those reasons, the court sets bond at $1 million cash or surety. Judge Hillman can modify that, as you know, Mr. Kaplan. But the court is going to err. I mean, with this, with the record before the court in this case, the court finds grave public safety concerns for the reasons stated, and the bond's $1 million cash or surety. Anything additional, Mr. Kaplan?
Not from the defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Ball. Take care of yourself.
Oops, sorry for the pause there, guys. I was in the middle of trying to monitor another courtroom. Good morning. It is hour 2 of TCF Live on a Monday. Let's go to Florida. Wade Mercer.
Mr. Poole, good morning. Mr. Poole, you're here because you've been accused of one count of battery. Mr. Poole, there is probable cause for the charge. The good news is I see no prior criminal history on what I've been provided this morning. And I'm going to listen to the attorneys before I set your bond or your release status. Mr. McDaniel.
Your Honor, we just asked for a cash bond.
Mr. Mitchell.
No objection to that.
Mr. Poole, I'm going to let you pick. I always give a choice. You certainly can choose a cash bond if you wish. Your options are conditional release or cash bond of $250. Mr. Poole, you have a condition to have no contact with the alleged victim, who is, I believe there's a typo on the complaint. I believe it's Barnes.
It was a bunch of names, but it was.
It's like 1, 2, 3, 4, 5 names in her name. I think, is Barnes her last name? Do you know, Mr. Poole?
I couldn't even tell you.
Or I don't know if it's, anyway, the person that's accused of this, no contact with that person and no contact with the property where this allegedly occurred. The disturbance allegedly occurred on 6351 Butler Road. So no contact with that property, Mr. Poole. Your grandmother doesn't want you back there, at least for the time being. Now that may change, but you gotta figure out what's going on and what's causing this. But for right now, no contact with that property and no contact with the alleged victim. Mr. Poole, you'll get to use the phone in a few minutes to try to post the bond. We're also going to give you a notice for your court date, Mr. Poole, which should be July 27th.
Yes, sir.
July 27th at 9 a.m. The jail staff will give you the notice for that court date. Do you have any questions? No?
No.
Have a good day, sir. Well, he's choosing the cash bond, right, Mr. McDaniel?
Yes, Your Honor.
Next case is Tyler Neal. Like, if he wants a conditional release, we'll bring him back up in just a minute and make sure that's what his choice is. Let's do Mr. Neal's case first. State versus Tyler Neal. Mr. Neal, good morning. Mr. Neal, you got a couple of issues. You have a hold out of Bay County. That looks like a child support matter. It has a $6,000 purchase amount on it. In Jackson County, you have 3 charges. They are driving while license suspended or revoked, habitual, driving with no motorcycle endorsement, and failure to register a motor vehicle. There is probable cause on those 3 Jackson County charges, but I think you're entitled to a bond on those as far as I can tell. I'm going to listen to the attorneys before I make that final decision. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing, Your Honor.
So, Mr. Neal, the felony driving while licensed suspended habitual bond will be $5,000. The other two cases will be $2,500 each. Mr. Neal, your total bond is $10,000. It's cash or surety. Cash or surety means you do not have to come up with all the money. You can go through a bondsman. You'll get a chance to use the phone in a few minutes to try to do that. So if you post a bond here, you'll go to Bay County unless you're able to post both. If you post the bond here and the purge in Bay, you'll be released. If you don't post either of them, you'll deal with our charges first and then go to Bay later. Your court date in Jackson County, which I'm going to ask the jail to give you a notice for, should be August the 4th at 8:30 a.m. That'll be in front of Judge Garcia. Mr. Neal, you do have a condition not to drive a motor vehicle. If you get your license issue straightened out, you can certainly come back to court and ask either myself or Judge Garcia to modify that condition. I think your habitual time period is over, but it looks to me like you've got to pay a reinstatement fee and then also pay some other issues with DHS and V before you can get a license. Mr. Neal, do you have any questions?
No, sir.
All right, sir. I wish you the best. Next case we have is Michael Worthy.
Take care,
Mr. Worthy, good morning. This is Mr. Poole. So, Mr. Poole, I didn't ask you, do you want to choose the bond or the conditional release?
What is the conditional release?
That's what I told you, explained it to you. You want that?
Yeah.
Okay.
So I'm going to grant you the conditional release, but I'm only going to grant you the conditional release if you have somewhere to live. So I know that you can't live there on Butler Road. Do you have somewhere else you can live?
Yes, sir.
Where?
It'll either be my mom's house or my best friend's house. That's the only options I know.
Your mom lives there on Butler Road, doesn't she?
No.
She doesn't live there next to your grandmother anymore?
No. She's got her own house now.
Okay.
Sir.
So as long as we can verify he has a place to go, I have no problem giving him a conditional release.
Yes, sir.
I don't want to bring him up here and waste y'all's time though, Lieutenant. So if y'all can let him use the phone, and if someone tells y'all on the phone that he can stay there, then I'm fine with that. We can go ahead and bring him up and instruct him on the conditional release. So, Mr. Poole, they're going to let you use the phone before you leave the jail to make sure you got a place to live. If your mom says you do, and it's not on that property, then that's no problem.
Okay.
But we want to verify that. Otherwise, you've got the right to post the bond. Okay.
Okay.
Should be the first one. We have Michael Worthy next. Mr. Worthy, good morning. Mr. Worthy, good morning. You were first appeared this weekend for first appearance on a violation of county probation in case 23-601 CT. I'm appointing the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I swear to Mr. Worthy, he's going to admit that he violated probation, understanding to be sentenced to 90 days in the county jail, 11 days jail credit, remaining fine. That will resolve this case today.
Mr. Mitchell?
That is agreeable with the state, Your Honor.
Mr. Worthy, did you hear that agreement?
Yes, sir.
Mr. Worthy, do you have any questions about the agreement?
No, I wish I could get reinstated on probation, but they said no.
Yeah, there's no chance of that. You got instructed and you never came back. It took us 3 years to get you back here. So I'd be foolish to give you another shot at probation. That's just not going to happen. But you don't have to take this offer if you don't want to. If you want to resolve it, you can. You want to take this offer and get it resolved, or you want to
I'm ready to go home, man.
Okay, so do you want to take this offer and get it resolved, or do you want me to just set you for a VOP hearing?
No, I'm ready to go.
You got to tell me you want to take the offer. Do you want to take the offer?
Yes, sir, I want to take the offer.
Okay. Just want to make sure, Mr. Worthy. So I'm going to accept your admission that you violated the terms of your probation, sir. In case 23-601, Mr. Worthy, I'm going to revoke that probation, sentence you to 90 days in jail, but you have 11 days credit. You have court costs and fines remaining. It's the full amount, Mr. Goosen. $400 court costs and fines remaining. Mr. Worthy, as Mr. McDaniel's probably told you, hopefully you'll get in the trustee program and get you some extra gain time and get out of there quite a bit earlier. That's what I hope happens. Mr. Worthy, do you have any questions?
No, sir, thank you.
Wish you the best, Mr. Worthy.
Thank you.
Yes, sir. We have Joanne Davis. Ms. Davis, good morning. You're here in case number 26-209 CT. I don't have the original charge on here.
I think it was driving my license suspended, revoked.
Driving my license suspended or revoked. Ms. Davis, I know that you've been in jail between here and Alabama for several days. I think we're going to try to get this case resolved. I'm appointing the public defender's office to represent you, ma'am. Please listen to Mr. McDaniel.
Your Honor, I spoke to Ms. Davis, and she's going to plead of no contest to the charges listed. Your understanding, just pay a $400 fine within 60 days, or she'll serve 10 days in jail. The only issue is that she's probably already served 10 days. She's already been in jail for longer than that, I think, Your Honor.
She told me this weekend, Miss Davis, and she was arrested on local charges. And then she finished her local charges up there and then had to come up here. So Miss Davis, when did you finish your local charges, ma'am, in Alabama?
I finished them June when I bonded out. I got just arrested on this warrant right here and held.
Okay, that's right. You told me that. They told you about the charge. You didn't take care of it, but then you got rearrested on it. And the second time they arrested you is when you got transported. So when did you get arrested the second time?
July 7th, Your Honor.
Okay, so we're not quite at the 10 days. We're getting close. 7 days, Mr. McDaniel, is that what you said?
Yes, Your Honor.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Davis, is that the plea you want to enter?
Yes, sir.
Ms. Davis, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly. Withhold adjudication of guilt, ma'am. Sentence you to 10 days in jail. Give you credit for 7 days you've already served. But you're going to be released today. As long as you pay the court costs and fines, they're $400. They're due by September 14th. If you get them paid by September 14th, the case is over. You do not have to come back to court. If you don't get them paid by September 14th, you need to be back in court September 15th at 8:30 a.m. to try to request an extension. I'll listen to you and make a decision on whether I'll grant that or not, depending on what you tell me. Sometimes people say, Judge, I got half of it paid. I need another couple of weeks, and I'll consider that. Miss Davis, if you're able to get your license, ma'am, by that due date of September 14th, that'll save you $100. So if you get your license issue resolved and you show proof of that to the clerk of court, your fine won't be $300. It'll be, it won't be $400. It'll be $300. So Miss Davis, you're going to be released today. Just take care of that by September 14th or be in court September 15th. Do you have any questions?
No, sir.
All right, man. Wish you the best.
Thank you.
Yes, ma'am. And we have State versus Lewis Phillips Jr. Mr. Phillips, good morning. You were first appeared this weekend for the charge. Good morning. Charge of driving while license suspended or revoked knowingly. I'm appointing the public defender's officer to represent you, sir. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Lewis. He's going to plead no contest. The charges listed. The understanding he'll be sentenced to 60 days in the county jail, 2 days jail credit, $400 fine. He has signed his plea waiver, waiving his right to a jury trial and call witnesses.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Thank you. Mr. Phillips, did you hear that agreement, sir?
I heard the agreement, Your Honor.
Do you have any questions about that agreement?
Yes, Your Honor, I would like to get put on probation. I have a job.
Tell me where you're working at.
I work for a trust company. I'm a welder. Trust company out by Sunland, by the airport.
Hang on, let me get you your paperwork here. Man, this. Mr. Phillips, the reason the jail offer was made is because you just did a jail sentence, I think maybe around December. Is that right?
Yes, sir.
Yeah, so that's why you weren't offered probation, but let me take a look at. Yeah, so under employment on your pretrial release sheet from the jail, it says employment not applicable. So
not applicable when I was in jail the first time, but I got hired out there.
Okay, this pretrial release sheet is from this weekend. This is from this weekend. This is not an old. So, well, no, you know what? Let me see. It's not dated. Yeah, this should be from this weekend. So how long have you worked at the trust company?
I've been there for 3 months. We build pole barn, metal trusses. I'm a welder.
Well, you probably make pretty good out there at the trust company, then if you're a welder, what kind of hourly rate do you make out there?
I make 18 an hour.
Okay. He has 2 priors, but they're older. I mean, 10 to 20 years old. The jail offer was primarily because of his overall criminal history, which you see here. And secondly, because he just got a jail sentence in December. That was not a driving offense. The charge in December was some type of
it was
interfere with first responder on duty.
Yes, sir.
Yeah,
Yes, sir.
allegedly not
Yes.
following the directions. Mr. McDaniel, I think my preference would be perhaps to set a sentencing for tomorrow and give you and the state a chance to speak with the employer, because that may affect what I would do. If we can verify that he has a job still, and that if they say he's a good employee and he's still gonna have a job if he gets out of jail, then that might affect what I do. Mr. McDaniel, what's your thoughts?
No, it's fine with me, Your Honor.
Mr. Mitchell?
Yeah, that's fine with me, Your Honor.
So what I'll do, Mr. Lewis, if you want to enter this plea, it's not going to get any worse, and it may get better. So what I would do is I'll accept your plea if this is what you want to do. And then what I'll do is I'm going to set a sentencing for tomorrow morning and give both your attorney and the state time to look further into your employment status. Is that what you want to do?
Yes, sir.
I'm going to accept your plea of no contest to the charge of driving while licensed, suspended or revoked knowingly. I'm going to find that plea is freely and voluntarily entered in, Mr. Lewis, but I'm going to see you tomorrow morning about 8:30 when we do first appearances. I'm going to ask Mr. McDaniel and Mr. Mitchell to see what additional information they can get. You also get a chance to use the phone. So if you contact friends or family, if the employer can't be here, if they can be here, that'd be best. If they can't be here, a letter from your employer or your supervisor will be the next best thing for me to consider to possibly help you. Okay?
Okay.
All right. You'll get his phone shortly. I'll see you in the morning, sir.
Yes, sir.
It's got to be Mariana Trust. They have 2 businesses there.
Mariana Trust.
But they're the same ownership, I think. Mr.
You can say it's
Mr. Gopinath Ross, both of them.
Trust, number 4.
The number 4 T.
Right across from Sunland, right?
No, sir. This one is back there where road right trailers used to be.
Oh, I didn't know they had a trust company back there.
They just moved there from Bluntstown.
Okay. Well, it doesn't matter to me. If you work for a trust company, it doesn't matter which one. It's not going to affect what I do. I just want to see if you have a job. If they say you still have a job after your arrest, then that tells me they want to keep you, that you're a good employee. So let's see what information we can get. Okay.
So is it Mariana Trust Inc. or?
No, it's not Mariana Trust anymore. It's 4T Trust. Is that what you said, Mr. McDaniel?
4T Trust. 4T Trust.
4T Trust.
Yeah.
It's right.
That where the trailer place used to be on the backside. You turn there by what's the new equipment place sells the heavy equipment? Yeah, by the Case dealership. Yes. Used to be an aeronautical place right in there too. All right. So, Mr. McDaniel, that's it as far as I have on my list. Anything else on first appearances, sir?
Nothing else, Your Honor.
Thank you. Lieutenant.
Alrighty, friends, hour 2 of TCF Live. Let's go to Texas. We will say good morning to Judge West.
Zarek, and this is cause number 26 DCCR 0317. Mr. Zarek's charged with driving while intoxicated with a child passenger. And what is the announcement?
Yes, Your Honor. We've received the offer in this case. We're just asking for additional time to
I have no issues, Your Honor. I've given 2 alternative offers, and that may allow some time for them to get some mitigation documents for me.
All right, thank you. So we'll just do a normal reset. It's about 30 days or so. Make sure you stay in touch with your attorneys. They'll let you know when you need to be back. You can visit with them between now and then about all of the discovery in your case, and we'll see if we can get an announcement.
It looks like the media has been tendered.
Okay, thank you, Ms. Malvino. Okay, thank you. All are free to go.
Yes.
I emailed the ombudsman back. Okay. Oh, wrong person. Gotcha.
You should be with me before you can hop on the speed boat, okay? You're bringing it.
All right, looks like she might need a moment or two to rack up the next contestant, so let's march across the hallway. Judge Stevens.
Yes, I was. Give me a summary of what we're doing on Mr. Jones here.
Just heard it statement.
If that one, okay, hold on. Okay, this is a second-degree felony of robbery.
Yeah.
He was an habitual felon 3 convictions ago. And we're pleading it to state jail.
Your first big fish, huh?
Is that what we're doing?
That's what I understand from Mr. Hanson.
Y'all gotta talk to me about this one. Now, how can
Mr.
I don't care, he was indicted as a,
I understand your.
may I speak? He was indicted as a serious felony offense, crime of violence. He has 4 prior felony convictions. He was an habitual felon 2 felony convictions ago. He was a habitual felon in 2013.
I know to say that there's a piece of vital evidence missing a video, and also there's co-defendant had something. I don't know who the co-defendant was. We look.
It represents a report, not a discussion for this. He indicated to me that he reviewed the file and he told me the facts corresponding to the identified person.
Correct me if I'm wrong, but robberies are done with theft being a part of the elements of the offense. You have to commit a theft to get a robbery.
That's why it's a lesser.
I know that, but that's not the way grand jury indicted.
Trust Mr. Hanson evaluation, Your Honor.
Well, they asked the the prosecution asked for the grand jury.
That's you.
I can only put my
presentation.
I can only assume that Mr. Ham, upon further evaluation of these facts and actually the idea of having to present the cat facts to the jury was comfortable with it being a theft of the person as far as his level of proof. And this one, like predicated.
I'll see if there's anything Mr. Laird can. Because I'm answering a little bit this too. It's a rare event that I ever.
Evidently, the co-defendant investigated 1 year county jail. After revocation of probation, got 2 years probation, then got a revocation for 1 year. What happens?
That's all y'all can really see. I'm looking at probable cause. It's not long. Anything else?
Doesn't look like anyone was hurt. Seriously, just had the scuffle.
Yeah.
If we go more, second shield.
Nobody knew what that was when they brought it for grand jury. Why do and ask for a grand jury indictment on robbery? Presumably.
It's the issue with the horizontal system. I can say in Orange County, just as a point of reference, that there's a vertical prosecution. Some of the cases presented, it was presented by the attorney that's going to try the case. So there's a little bit different perspective on the cases that are actually evaluated.
Yeah. You don't see anything readily, though.
I don't see anything to really cause you to reject it either, Judge. It's a shoplifting that was.
I'm not gonna take it.
A scuffle at the end.
I'm not gonna take it.
Okay.
We'll just move on.
Well, then we'll need to reset it to review.
I understand.
Renegotiate.
It's not gonna be placed on, it's not gonna be placed in trial today.
Yes, sir.
All right. Kinder Antoine, Mr. Manel, I guess. Yeah.
Well, he racks up the next contestant, Barbara. Earlier, apologies, I got caught up in other things I forgot. 15 months with us, so very cool. Thank you for that. And also, you left $5 for the Ellie Trito Fund, so thank you for that as well. I appreciate it.
Cases do you have to do?
Just two.
Oh, they clean the boat? Or?
Just one.
Which one?
And he's clean to, gonna be the 1606, and then 1607 will be dismissed.
Okay.
I don't think I have this. Oh, 7 is the dismissed.
Yes, Reagan. Here's one. It's Tom's. Yes.
I don't have.
I sent it on the tablet.
Well, I know it's on the tab, but I don't have the. It was never pulled.
Yeah.
Oh, yeah.
Yes, right.
If we can reset, we call it, Judge, and I'll figure it out. I'll sort it out.
It's a plea.
All right, I'll do. One more.
Yeah, what's the last one?
And if we can put that on recall and I can go upstairs and grab a file, please. They just have to go grab it.
Yeah, see. What do we have next? Is
Looks like he's going to need a minute to find who he needs to deal with next as well. So once again, let's march across the hallway back to Judge West. This looks like a proper Monday morning fashion show contestant.
Okay.
So you're Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh, you were here just last week or the week before.
Yes, ma'am.
And you pled guilty to an offense and you were told to go to the probation department and do a pre-sentence report.
Yes, ma'am.
And I've gotten a memo from them that has some unfortunate information in here about how you acted while you were there and visiting with them.
Yes, ma'am. I was over the phone when the lady was arguing and stuff. I just wanted the information on when I was supposed to meet the dudes. That was it. And
That's not how this reads.
they
They were so frustrated with you that they said they will not do a pre-sentence report while you're on bond. So do you know what that means?
my bond had to be paid off.
No, that means I'm going to revoke your bond
Okay.
and you're going to go to jail.
Yeah.
And then they're going to come to the jail and do the pre-sentence report. And you're going to be respectful to them. Or I don't have to go along with this plea agreement.
Yes, ma'am.
So listen, it's time to get a whole different attitude about all of this. I understand. I remember now when you were here, you don't like the whole situation.
No,
Hang on, don't overtalk me. Because that's going to show me what you're doing to them. Okay. Now it's just the time to listen.
Yes, ma'am.
All right. And just do what you're told. There's not an excuse for what you did. That's not, you didn't just try to ask for some information. Okay. They wouldn't have sent this. They're very, very patient.
I just want to let you know I got a whole different view about it on the whole situation now too. I just got to meet my son for the first time on Friday. So
Well, this is very unfortunate.
Yeah.
So you'll, but here's the thing. There's no reason for you to still not get this probation, but I don't have a choice now, but to get this pre-sentence report done. So I'm going to, hang on, I'm going to revoke your bond. In your case at this time, you're going to go with the bailiff. Probation's going to come to the jail. They're going to do this pre-sentence report, probably not today.
do I get a new bond today?
I'm not giving you a bond because you couldn't act right while you were on bond, which shows me that you see where I'm.
Yeah,
the
can
problem-
we just like revoke the deal and take it to trial? I can't afford to go to jail, please.
You're going to jail regardless. Why?
Yeah,
Because, do you want me to read the memo?
the whole thing, yeah, can we play the voice recordings of the phone call in here today too, if that's the case? Because if you're just gonna believe what she says, then I believe I have the right to fight on behalf of what I have to say, and we need to be able to play those phone recordings.
You're gonna go do that, you're gonna go do that pre-sentence report.
Phone recordings today.
And you're gonna go and hopefully be respectful and hopefully get this probation and not ruin your life over this. This is very,
How long do you think I'll be in there?
it's a very temporary situation. Mr. Rojas can come back and talk to you. I'm revoking your bond. At this time, I find it's in the best interest until sentencing that there not be a bond. You can go back with the bailiff. Was he? Well, I don't know, maybe, I mean, if he, maybe I'll have him just sit for a little bit. Let's just see.
Judge,
Mm-hmm.
since we have him here, well, let's go ahead and test him.
That's a great idea. Let's do that as well.
The problem, I know what they did get out of the PSI from what they could barely read was some marijuana and fentanyl use. So maybe, I don't know, it just seems.
That's a great, yeah. Thank you, Mr. Nichols.
Yes, sir.
We'll do that as well. And he's already here, so let's get that done.
Alrighty, we'll keep an eye on this court. Let's head back up to Michigan. New contestant, Judge Prill.
People, State of Michigan versus Matthew Robert Hartman, file number 267453 at this stage. It's time to date set for sentencing. Mr. Hartman is present, represented by attorney Kyle T. O'Mara. People are represented by prosecuting attorney Timothy J. Wachowski. Back on May 11th of this year, the defendant entered a guilty plea to failure to comply with reporting duties. Ms. Karen Everland prepared the pre-sentence report dated June 30th of this year. Mr. O'Mara, have you and your client had the opportunity to review the report? Yes, Your Honor. Any additions, deletions, corrections, or objections?
Your Honor, first I would note, I did contact Ms. Everland last week regarding what I believe to be an addition that was mistakenly included in the report. I spoke to Mr. Lake this morning, and I believe he has an update for the report. Mr. Lake?
On the second page of the 145, we're going to omit or get rid of 1.6 and 1.7 conditions on count 1. They show up as number 2 and number 3.
Yep, got it. Thank you. Anything else, Mr. O'Mara?
Your Honor, just by way of update regarding my client's employment. Since this report was generated, on page 12, it indicates his employer's name, where he's employed as a carpenter. He has been laid off from that position. He's still working as an independent contractor as a carpenter, but not regularly for that particular employer listed on page 12. So
noted.
That the update.
Yep, so noted. Anything else, Mr.
No, Your Honor.
Mr. Hardwick, is there anything else of the report other than what your attorney has stated that we need to address? No, sir. Mr. Wachowski, any objection to the report as well as guidelines? No to either question. Thank you. Any objection to the report of the guidelines? No, Your Honor. Anything you'd like to say on behalf of your client?
Yes, Your Honor. Your Honor, there's no indication in the discovery material or certainly in speaking with Mr. Hardwick, no indication that he was intentionally undergoing any effort to evade his reporting duties. He explained to me, and I think it's a very useful explanation. When he was originally convicted of the offense that triggered the requirement to register under SORA, he was informed that his registration period was for 25 years. He was convicted in 1998. He was sentenced to prison and served a 2-year prison term with parole in 2001. So he was under the impression that that 25 years commenced on the day of conviction rather than his release from incarceration. So he was under the mistaken but reasonable impression that 25 years was up. He wasn't under any obligation to report. Obviously, that's not the case. He's aware of that now. He has reported as required. In fact, even to make sure he didn't have any issues moving forward, he did report last week to the Sheriff's Department his update regarding his employment. He
make sure everything is above board. I think that this offer takes some of those factors into account. I think Mr. Hardwick is going to be a mild probationer while on the period of delay, if the delay is granted. I would ask that the prohibition against alcohol be removed. There's no indication that Mr. Hardwick has a problem with alcohol. There's also no indication that alcohol was all a factor in this offense. It's an issue, but I don't think it's necessary. Mr. Hardwick is perfectly willing to apply with any testing that may be ordered by the court regarding controlled substances. I would also ask, in light of the fact that he's recently been laid off, I'd ask the court to waive attorney fees that have been recommended. Otherwise, I'd ask that the court adopt the recommendations.
So if he's allowed to consume alcohol, why would he test for alcohol?
Well,
that's being requested as well.
Yes.
I know drug test.
Yes, sir. Before I hear from the defendant, Mr. Lick, what's your position on this?
It's looking through the TSI report. I mean, I have no objection to it. If there's something that should something that down the road.
Okay, very well. All right, did your client wish to address the court, Mr. Romero? I believe he does. Mr. Harper, go ahead, sir.
I just want to say, kind of what he was saying. I wasn't trying to hide from anybody. I wasn't trying to, cause you guys problems or get myself in trouble.
It's not the court, sir.
Right.
It's the public at large.
It's, I was under the impression that I thought I was done. I should have done my part, checked a little closer into it instead of just making the decision to be like, oh, probably should have asked somebody and then we wouldn't be here today. But, rules I understand.
Thank you, sir. Mr. Rakowski, anything on behalf of people?
Your Honor, the pre-sentence investigation report really lays out everything that happened in this case and the history for Mr. Hartwick. Mr. O'Mara is correct. We took this into account when we decided what the offer was that we have extended. So we asked you to adopt the recommendations as set forth in the pre-sentence.
Mr. Rakowski, what is your position relative to the alcohol provisions?
We don't have the benefit of having Miss Eberline here as to why she put that in there. That's my thing. So I would rely on the fact that she's requested it, so we would ask for it.
Well, Mr. Hartwick, as you know, ignorance of the law is no excuse. And when you have to comply with reporting duties, you're getting at that end stage, fortunately. But at the end of the day, it's for public safety. So that's why it's required and you have to follow through. But I accept your explanation. It will be the sentence of this court that the defendant be placed under the delay sentence statute program for a period of 1 year. Conditions of probation include the standard conditions. You're not to violate any criminal law of any government. You're not to leave the state of Michigan without prior approval of the court. You are to notify the probation agent at least monthly or such times and places the agent may require. You must register, continue to register on the registry, comply with all the conditions, and have with you all your proper materials. You are not to access the internet using any device prior to completing and signing the MDOC internet use agreement, and you are to abide by all conditions of that agreement. Failure to adhere will be considered a violation of probation. You are also to waive confidentiality regarding CMT meetings, allow disclosure and exchange of that information between the department, including its authorized agents and CMT members. You are not stated not to leave the state without prior approval of the court. The court will strike paragraph 8 and 9. However, paragraph 10, you must comply with all the requirements of drug testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing or hinder, obstruct, tamper, otherwise interfere with any of the testing procedures. You are not to use or possess any controlled substance unless prescribed for you by a licensed physician. Can't be around anyone that possesses those items. You are also not to possess any drug paraphernalia or be around anyone that possesses those items as well. You are to complete any outpatient or residential substance abuse treatment when referred by the agent, as well as the substance abuse assessment. You are to truthfully report to the agent, as I stated, at least monthly or at times and places the agent may require. You are to complete any recommended treatment following assessment by a qualified community-based service provider. You are to waive confidentiality regarding any programs that you are to attempt to disclose that information to the agent. You are to notify the probation officer if you change your address or employment status. You are to possess either a valid state of Michigan driver's license or Michigan identification card. You are not to engage in any assaultive, abusive, threatening, or intimidating behavior. You are not to have any verbal, written, electronic, or physical contact without permission of the agent with anyone housed within an MDOC facility, nor the same type of communication or interaction with anyone that's engaging in a behavior that constitutes a violation of any criminal law on either the government. You are not to use any object as a weapon you cannot own, use, or have under your control or area control a weapon of any type, not even an imitation. You can't be around anyone that possesses those items. You are to contact the supervising field agent no later than the first business day following your placement on probation. Comply with all written and verbal orders of the agent. Allow the agent to your residence at any time for probation supervision, where you're subject to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause you of items that violate the terms of your probation. Any arrest, police contact, loss of employment, change of residence must be reported to the agent in 24 hours. You are to make genuine effort to find and maintain legitimate employment, a minimum of 30 hours per week with all other standard conditions there. Crime victims assessment of $130. Probation supervision fee monthly, regular $30 per month, electronic $60 per month. Court cost of $200 will be imposed, payable at the rate of $20 a month. A fine of $200, payable at the rate of $20 a month. The court will waive paragraph 32 attorney fees. $68 in state costs will be ordered. If referred, you must successfully complete any PA 511 programming based on eligibility. Can I have a due date for fines and costs as well as the next sentence?
September 7th.
Costs are due and payable September 7, 2026, subject to the 20% late fee.
July 12th.
July 12, 2027. Mr. O'Mara, did your calendar go that far?
Certainly does, Your Honor. That'd be fine.
That'd be 90.
That'd be fine.
It's my duty to inform you of the right to seek leave to appeal if you're financially unable to provide counsel of your own choice. The court will assign counsel for a public expense. Please initially receive the questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court within 42 days. And the court record shall reflect the same as well. Good luck to you, sir. I want to see you in 1 year, not less than 1 year. And there's another thing that you need to be concerned about too. With anyone that's placed on delay of sentence or any type of probation, that's night.
Your Honor, Mr. Harwood and I have discussed that.
IHOP is a program this court embraces, and it keeps people on the proper channel, and we want to keep you that way too. Good luck to you, sir.
All right, thank you.
You're welcome. All right.
Alrighty, friends. TCF Live on a Monday. Mondays can be Mondays, but we can avoid Mondays being Mondays by hanging out with each other and having some fun here on a Monday morning as we go from court to court to court. Let's go back to... Yeah, let's go to Texas. Looks like we got the guy who got passed earlier from Judge Stevens. Looks like he's heading back up, so let's check that out.
All right, once again, which one's which? 1607 who's pleading?
No, 1607 is the dismissal. 1606 is the plea.
25 CR 1606 is called your Kinder Antoine with Miss Manali, your attorney and the state's attorney does. The defendant waived formal reading of the indictment and arraignment. Can we proceed in summary?
Yes, Judge.
In summary, the states that on or about October 13th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. We did both. Oh, okay. Okay, in 25 CR 1606, again, you were Mr. Antoine, your attorney and the state's attorney. And again, in summary, on or about October 13th, 2026, 2025, in Jefferson County, Texas, this state you committed a second-degree felony of assault on a peace officer by kicking the complainant in the stomach with your feet, and you knew the victim was a peace officer lawfully discharging an official duty. You understand which was arresting you? Do you understand what you're charged with here? Yes. This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine that be assessed not to exceed $10,000. You understand? Yes, sir. An agreement's been reached with you would be pleading guilty. So 2 years in prison. And then the other case, N607 here, would be dismissed. Is that your understanding of the agreement? Yes, sir. If I follow this, you have no right of appeal of your case. Do you understand? Yes, sir. How do you plead to this, guilty or not guilty? Yes. Are you pleading guilty voluntarily and because you are guilty? Yes, sir. Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Are the contents true and correct? Yes, sir. State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with, the indictments and the read to you. You read it. You were guilty of the crime charts and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. Yes, State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
You understand what you did wrong here? Yes, sir. What?
Something police officer.
Sir?
Something police officer.
Well, I mean, what do you think about that?
That,
I'm sorry.
I apologize about it.
Were you in your right mind? Huh?
No, sir.
Why not?
Can't explain this moment. It's just one of those things.
It was just not one of those things. I mean, you were assaulting, and then let's see. You stated some terrible vulgarities. Were you aware of that?
So,
You want me to say them out loud to the general public, or so that we all know what kind of person you really are?
no, sir. Not a bad person at all, sir.
Oh, I'm sorry. It's not what we think we are. It's how we act.
Right.
Isn't that right?
Yes, sir.
How did you act here? Poorly. Correct?
Right.
Okay. You are mentally competent to enter your guilty plea, the court finds. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. As you have given up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses, I now find you guilty beyond a reasonable doubt of this assault on a peace officer, a second-degree felony offense. I'm following this agreement. Hereby sentenced to confinement in the institutional division in the Texas Department of Criminal Justice to serve a term of 2 years. You understand what has happened today?
Yes, sir.
Anything else?
No, Judge.
That is all.
Thanks, Joseph.
I think I've got a dismissal on this too.
Don't have it yet.
I'm sorry, there's.
All right, friends, let's move along. I'm sure we'll be back to Judge Stevens later, but let's stay in Texas. Keep with this channel's promise of 9 to 11% more Judge Boyd. Give you Judge Boyd.
Yes, I will. All right, the court is calling 2024 CR 012208, State versus Kiancy Smith. Announce.
You're in the crane behalf of Mr. Smith, who's to my right.
All right, and are you Mr. Smith?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Sir, you need to have a seat. Just a moment. All right, Mr. Smith, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Well, that was fast. Let's see if we can move past this here real quick.
The fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yeah.
Do you believe he's currently competent and was legally sane at the time of the offense?
Very much so.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, Your Honor.
Okay, according to the plea, punishment is to be assessed at a cap of 5 years. The state is silent on your application. There's a $1,500 fine. There's to be registration, no contact with the complainant, TAP evaluation, MIC MIOF evaluation. And counsel, the court is aware that ADA Uncofer was a part of the plea bargain agreement and that there were some issues with competency.
We did have him evaluated. He came back clear, but just for the record, he does get a check from the government for mental disability.
Okay. All right. So, Mr. Smith, did you understand that as your plea?
Yes, ma'am.
State defense, is that the plea?
It is, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
None.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
No, no objection.
All right, state you may be excused. Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports?
Yes, Your Honor.
But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. We're proceeding with sentencing.
Yes, please.
Anything you wish to say on behalf of your client?
Just, Your Honor, his mother has been very involved in this process. He's got a lot of support back home. He does have a mental, intellectual disability. He does receive, I believe, an SSI. As a result of that, there were some concerns about that going in. I think we got him again cleared by the competency evaluation, but that report very well outlined his history of just limited, I think, cognitive understanding on some things, and also just, I think you're on a few medications as well. And so we'd ask the court to take that in consideration. I think he's a good candidate for deferred adjudication. He doesn't have a criminal record. We ask the court to give an opportunity.
All right. And I see in the stipulations that he was given his Amazon account information for somebody to use as well.
Yeah, that's correct.
All right. So is he going to be staying in Texas or?
He was arrested in Louisiana. This entire incident on his behalf took place in Louisiana. So he's not even from Texas. He would like the opportunity to go back.
Which parish?
Bienville.
Okay. All right. The court is going to sentence you to 5 years deferred adjudication. There will be a transfer to Bienville Parish. What city is that?
Arcadia, Louisiana.
Okay. All right, transfer to Bienville Parish. I don't know if that's Arcadia though.
It should be either Shreveport, Arcadia, or Monroe.
All right.
Or Ringgold.
Because I know it's, well, I know it's not Shreveport.
Could be Ringgold.
Okay, I'll look that up. All right, 5 years deferred adjudication, transfer to Bienville Parish, regular reporting by Zoom or in person, regular UAs, proof of employment or SSI, within 45 days of release, no employment as a home health care provider or with minors. Who will you be living with?
My mother.
And are there any minors in the household?
No.
Okay, no residing in households with minors. No unsupervised contact with minors. And I understand the facts of this case are a little bit different than normal, but I'm just putting this in here to make sure that things are as they should be. At some point in time, that can be lifted if, you know, he had brothers or sisters or something of that nature.
Thank you, Judge.
There's to be Chapter 62 compliance. There's to be no contact with the complainant. And we'll do a MIC evaluation. That can be done out of custody. Since he already has the SSI, they'll probably have the paperwork for that. And do you have a doctor back in Louisiana?
My main doctor, she moved out on her name, and my mom knows all the information. I don't have any.
All right. And there's to be continued mental health treatment. And is that a private doctor?
No.
Do insurance is public?
Yes, ma'am.
All right. All right. He's to do continued mental health treatment. And we'll have to find out where that is. Probation, there's also a $1,500 fine, and that'll be probated. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. We'll do no possession of firearms as well. All right, I'll let you.
Thank you, Judge.
You're welcome. Anyone else ready?
Now in hour 3 of TCF Live, this morning, like them all, is just marching on so quickly. Let's head back up to Michigan, new contestant in front of Judge Prill.
State of Michigan versus Rachel Marie Clark, file number 267444FH. Time and date set for pretrial status conference. Court is also calling a companion file, Ms. if you are not on this matter. It's file number 5900FH, People versus Clark, relative to allegations of non-payment of court costs and restitution. We'll address that one after this hearing. Ms. Clark is present, represented by Attorney Michelle R. Sipp. People are represented by Prosecuting Attorney Timothy J. Rukowski. Court just received an advice of rights form. Is there a plea offer that's been extended here, Ms. Sipp?
There has been, Your Honor. It was the original offer that was originally extended. And I wish to extend that.
All right. Ms. Clark, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Mr. Rukowski, would you please state the terms of the plea offer?
Yes, Your Honor. Ms. Clark would be pleading guilty to both counts in the information and being habitual offender, second offense on each count. People would agree not to file further habitual offender notice or withdraw, because I think we filed the additional amount, withdraw the habitual offender notice that we filed. And then Ms. Clark also agrees to pay full restitution.
So habitual offender 2, correct?
Yes, Your Honor.
Ms. Sipp, is that your understanding of the plea offer?
It is, Your Honor. And also, we would most likely have to have a matter set for a restitution hearing.
Okay. And Ms. Clark, is that your understanding of the plea offer?
Yes, Your Honor.
And do you wish to accept it?
Yes, Your Honor.
Are there any other terms to the plea offer that we've not covered on this record?
No, Your Honor.
Have you had sufficient time to speak to Ms. Sipp about this?
Yes, Your Honor.
Do you need any additional time to speak with her?
No, Your Honor.
Is there anything affecting your mind or brain making it difficult to make important decisions?
No, Your Honor.
Your mind?
Yes.
And regarding the plea offer, so that we're clear, I just want to make absolutely sure. If I asked this already, I apologize, but there are no other terms to the agreement other than what's been placed on this record, right?
Yes, Your Honor.
Ms. Sipp?
I agree.
And Ms. Burkhouse?
I agree.
Ms. Clark, you are not on probation or parole, correct?
I am on probation.
In this court,
No, through Tuscola County
circuit or district?
Circuit.
You understand that this could affect your probationary status there?
Yes, Your Honor.
And you understand the ramifications, but you wish to move forward?
Yes.
Okay. Is there anything affecting your mind or brain making it difficult to make important decisions?
No, Your Honor.
You have a clear mind?
Yes, Your Honor.
Ms. Clark, you were charged in count 1 with home invasion, second-degree habitual offender second, which carries a maximum prison sentence of up to 22 and a half years and or a fine of up to $3,000. Do you understand the charge and maximum sentence being imposed?
Yes, Your Honor.
In count 2, you were charged for the offense of lying to a peace officer for a year or more crime investigation. That is considered a high court misdemeanor, maximum prison sentence of up to 3 years and or a fine of up to $5,000. Do you understand the charge and maximum sentence?
Yes, Your Honor.
All right. Understanding that then, as to the charges contained in the information alleging on or about Christmas Day, 2025, City of Harbor Beach, County of Huron, that you committed second-degree home invasion and lying to a peace officer for a year or more crime investigation. How do you plead?
Guilty, Your Honor.
You also acknowledge being previously convicted of a felony, at least in this court. That would be on or about April 27, 2015, the offense of larceny, $1,000 or more, but less than $20,000 in this circuit court.
Yes, Your Honor.
Just to be clear though, on October 20, 2025, you acknowledge being previously convicted of possession of methamphetamine or ecstasy in the Tuscola County Circuit Court.
Yes, Your Honor.
Is that the matter you're on probation for right now?
Yes.
All right, the court's in receipt of an advice of rights form. A signature on it, printed name of Rachel Clark, dated today. Did you sign this document, Ms. Clark?
Yes, Your Honor.
Now, before signing it, did you read it over?
Yes, Your Honor.
Did you also go over it with Ms. Sipp?
Yes, Your
Do you
Honor.
understand the rights contained on the form?
Yes, Your Honor.
By pleading guilty, you're giving up those rights.
Yes.
You will not have a trial of any kind or have any opportunity whatsoever to contest your guilt, and all that remains after today will be for you to be sentenced.
Yes, Your Honor.
If your pleas are accepted, you'll be giving up any claim that these pleas the result of promises or threats not disclosed to this court during the plea proceeding. You'll also be giving up any claim these pleas are not of your own free choice. Do you understand that?
Yes, Your Honor.
Other than the terms of the plea agreement outlined on the record by Mr. Rakowski, has anyone promised you anything such as leniency to get you to plead guilty?
No, Your Honor.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you to imposing sentence.
Yes, Your Honor.
Has anyone promised the court will be easy on you?
No, Your Honor.
Has anyone threatened you to enter these pleas?
No, Your Honor.
These pleas your own free choice.
Yes.
Court costs are due and payable at time of sentencing unless there's good cause shown. Do you understand that?
Yes, Your Honor.
And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence.
Yes, Your Honor.
Finally, if these pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeals for the convictions and sentences pursuant to these pleas will be by application for leave to appeal and not by right. Do you understand that?
Yes, Your Honor.
Ms. Clark, any question regarding any of your rights?
No, Your Honor.
Any questions of Ms. Sipp?
No, Your Honor.
Ms. Sipp, do you wish to establish a factual basis?
I can.
Please.
Ms. Clark, I'm going to take you back to December 25th of 2025, all right?
Okay.
Were you in the city of Harbor Beach, Huron County, Michigan on that date?
Yes, I was.
And on that date, did you enter a dwelling located at 421 School Street in Harbor Beach?
Yes, I did.
And did you have permission to enter that dwelling?
No, I did not.
While you were in that dwelling, did you take something or did you do something that you weren't supposed to?
Yes.
What did you do?
I took a dozen eggs and a Gatorade.
And did you have any intentions of returning that?
No.
And you had no right to do so?
Right.
And that was while you were inside of the dwelling again? Right?
Yes.
Then also, were you questioned by Harbor Beach Police Department, Officer Sergeant David Wilson?
Yes.
And you knew he was conducting an investigation in regards to you going into the home?
Yes.
And did you make any false or misleading statement regarding that investigation while he questioned you?
Yes, I was scared because of all my other charges going on. And just sick of being in trouble all the time.
What did you tell the officer?
That I was not in the home when I was.
And that was also in the city of Harbor Beach, County, Michigan?
Yes.
Right, I believe that.
Any objection to the factual basis?
Just a couple questions. Ms. Clark, you said that was a dwelling, so somebody lived at that house, right?
Yes.
But the homeowner had just passed away.
Correct.
With that, Your Honor, we believe that the factual basis has been met.
All right, Mr. Rukowski, you aware of any promises, threats, or inducements for these pleas other than what's been disclosed?
No, Your Honor.
Ms. Sims?
Yeah.
Has the court complied with the court rules concerning pleas, Mr. Rukowski?
It has, Your Honor.
Ms. Sims?
Yes, sir.
Ms. Clark, there's no agreement made by this court concerning the pleas and what the final sentence will be. Is that accurate?
Yes, Your Honor.
Ms. Sims?
I agree.
Mr. Rukowski?
I agree.
Court looks up the pleas. They're done freely, they're voluntary, they're understanding and accurate. A sufficient factual basis has been established by the defendant's sworn testimony. Sentencing will be scheduled for September 14th. Ms. Sims?
I'm available.
Sentencing September 14, 2026 at 9 a.m. Prior to sentencing, the court will order a pre-sentence investigation report to be prepared, provided to both counsel and court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines filed in writing with the clerk of the court no later than 7 days from sentencing. This clerk must appear in the courtroom at the time of sentencing. If there's any supporting documentation must be submitted to the court no later than 7 days from sentencing. Any objection or written response is filed 3 days thereafter. Bond was set at $3,500, 10% of this file. Mr. Rukowski, your position on bond.
We have no objection to continuing bond with the conditions as set.
Thank you. The senator comment on bond.
I already said that.
Bond will continue as previously set. That will address that matter. Clark, but I'd like you to stay there for just a moment. This 15th file the court has wants to advise you that a motion for show cause was filed by the clerk of the court in this matter, and it alleges, well, not alleges, it indicates that you were ordered by this court on June 8, 2015 to pay $20,724.25. You signed an installment payment agreement, agreed to pay $50 a month beginning February 2nd, 2022. Currently, $17,954.25 is still owing. The last payment, according to the Huron County Clerk, was March 4 of 2022. And they are alleging that you failed to comply with the court's order set June 8, 2015, the original sentence, as well as the installment payment agreement. And they are requesting show cause as to what is going on regarding payments in this matter. Do you have any comment at this time, Ms. Clark?
I did pay in April and May. I did pay them. And the reason I have not paid since then is I did not pay in May, I'm sorry. I was involved in an automobile accident that totaled out my vehicle, and it pushed back my surgery date on my knee. And now I'm facing a neck surgery along with my knee surgery and other surgeries coming up. So, I mean, I had to save up as much as I could to get myself a vehicle so I could get to my appointments and get to the courts and everything else. So that is one of the reasons that I have not paid, but I am willing to get back on the track the end of this month.
End of this month?
Yes.
Because, and I mean no disrespect, Ms. Clark, but your statement and reasoning for it, again, if you tell the victim that, it doesn't matter.
Yes, I
understand
know.
that.
Yes.
I mean, this has been ongoing since 2015. the recent, it's sad to hear or sorry to hear relative to the car crash or whatever may have happened, but you've had since 2015 to get this thing started. So I will, at this point, accept the payment plan that is currently entered in this matter. And your first payment will be in August when?
August, 1st.
August 1st. And each first day of the month
Yes,
thereafter.
yes,
But I do want to revisit this in 6 months.
okay.
If there's any changes or updates, to the extent that it can be paid more, we want that to be addressed.
All right.
Any questions?
No, Your Honor.
When you leave today as well, and you probably have to speak with the probation department, make sure you stop by the clerk's office, county clerk, right around the corner, let them know what happened as well regarding this file.
All right.
Can you do that, please?
Yes.
I appreciate it. Thank you. Thank you, sir. That'll be all.
Alrighty, friends, hour 3 of TCF Live. Let's go back to Judge Boyd. Looks like we have a contestant via Zoom there.
Thank you.
Thank you. All right, and Mr. Gonzalez, you signed the acknowledgement of discovery?
Yes, ma'am.
All right. The court is calling 2020 CR 6198, State versus Jesse Jason Gonzalez. Can I have parties announced for the record?
David Levinson, on behalf of the defendant, ready.
All right. And are you Jesse Jason Gonzalez?
Yes, ma'am.
All right, the defendant is appearing by Zoom. Mr. Gonzalez, you have a right to appear in person in court. Do you understand?
Yes, ma'am.
Are you requesting to proceed by video?
Yes.
All right, and the court will note that the defendant is confined in another jurisdiction outside of Bexar County. Defense, do you have any objection to your client appearing by Zoom?
No, Your Honor.
State any objections? Court will find that defendant has knowingly and voluntarily consented to appear by Zoom. Mr. Gonzalez, did you review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney, and did you understand it?
Yes, ma'am, I did.
Are you the same Jesse Jason Gonzalez who was placed on deferred adjudication in 2020 CR 6198 for the offense of unlawful possession of a firearm by a felon on July 8, 2020 for a period of 5 years and extended for a total of 3 years? Is that you?
Correct.
All right, state.
On state supplemental, motion to supplement pending MTR violated condition number 5 in Bexar County, Texas. The defendant, Jesse Jason Gonzalez, did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2026 in violation of the laws.
How do you plead to that? True or not true?
True.
He will waive your review.
Any objections to the waivers?
No, Your Honor.
Mr. Gonzalez, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you to 10 years in the prison?
Yes, ma'am.
Up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
It is not good, but state would be asking that you grant state's motion, enter an adjudication of guilt, revoke, and sentence to 5 years in the prison. Judge, this is Mr. Gonzalez's third MTR, and what remains consistent throughout is he has a fundamental inability to do one of the most basic things on probation, which is to report. Not only that, obviously, he is in custody in another county, so he cannot comply and comport his behavior to that consistent with what is required by him on probation. And I think because this is his third MTR, he's been given ample opportunity to comply with conditions, that there's not much else he can do. So for that reason, we would be asking for revocation at this time.
Defense?
I would like to present some evidence, a witness on his behalf.
Yes. Who would you like to call?
Jesse Gonzalez, his father.
All right, Jesse Gonzalez. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jesse Gonzalez.
All right, defense, you may proceed.
What do you want to tell the judge on your son's behalf? Can you talk to the judge a little bit about him?
He's been a, first of all, he lost his mother when he was 17 years old, and he got into some issues as far as legal issues, and I've been trying my best to calm him down. He eventually now he gave me a granddaughter, and he's expecting his girlfriend is expecting a grand boy, and within days. He has been a real good kid, but you know, it just, yeah. I talk to him every day. I just pray for him to get better.
If the judge allows him to continue on probation, would you said you would talk to him every day?
Yes,
Do that?
absolutely,
Would you help him be able to report?
absolutely.
What's your understanding of his failure to report? But
If I would have known that he had to report, I would have been on his tail. But I didn't know.
how many other children do you have?
I have two older adults,
And
a 43-year-old and a 37.
and how are they doing?
They're doing great.
What does your older son do?
He owns an air conditioning company.
And your others?
My daughter works for him.
Okay. And is there anything else you'd like to say?
State.
Mr. Gonzalez, my name is Lauren Espinoza. I represent the plea. I have a few questions for you to follow up with what you just testified to, okay?
Yes.
So you just testified that had you known your son was to report, you would have been on him, correct?
Yes, absolutely.
Does he reside with you?
He did it sometimes, but not now. He lives in Uvalde.
Approximately what time frame did he reside with?
About a year. Well, probably the time that he had gotten arrested.
For this case?
Yes.
So about 2022? So 2019 to 2020?
It was there probably.
Or can you narrow it to a specific year for me? Is it in 2020?
24.
So he resided with you in 2024. But the instant case we're here for is alleged to have occurred in February.
Oh, no, okay, no, he didn't live with me.
Okay, so he didn't live with you at the time of this comment. Okay, and would it surprise you to learn that it was alleged that police were dispatched for a burglary and then found him with a firearm?
I knew of it, yes.
Okay, do you know him to own firearms?
No, he never owned a firearm that I know of.
Do you know why he would have been in possession of a firearm?
No.
Okay, did he have children in 2020?
No,
No, so it was after this case that he had a child?
yes.
So-
My granddaughter's 2 years old.
Okay, so how can you assure the court that you're going to make sure Mr. Gonzalez complies with probation when he's his own adult with a child?
I will definitely make sure.
But there's no way for you to make sure that 100%.
Of course. But, yeah. Being as father, I will.
Any further questions?
No.
Thank you so much for coming in, but this is what I want you to realize, right?
Yes, ma'am.
As a parent, because how old is your son?
25.
All right, he's 25. It really is not your responsibility to make sure he reports. So I want you to know that everything that you've told me has given me insight into your son. It doesn't negatively impact him, what you've told me. All right, thank you so much.
I would just like to make a statement closing on.
Sure.
I'm going to do that now.
Well, let's let the state go first and tell me what they want, and then I'll come back to you.
Judge, we're asking for 5 years in the prison. Mr. Gonzalez is here on his third MTR. He does have a prior probation that he was terminated unsatisfactory in 2024. So because of that.
All right, in defense, what are you requesting?
Your Honor, this is an unusual case for me. I know you see these cases every day a million times. So, in that light, it's kind of difficult to give you something different or why this case is different than your past rulings, either favorably or unfavorably. All I can say is that I've known this family my whole professional life, like 30 years. I've known Mr. Gonzalez, the father. I've known his children, all of his children. I've done cases like divorces and this and that. And they're good people. They own businesses, as you heard, and his brother is a very successful executive. There's been some issues with the family with this child, and you'll see that it's confirmed in the probation report on page.
Just a second. Do you have the trial court certification back yet?
Not yet.
Right.
The recommendation of the probation department confirms kind of what I'm saying, in the sense that they're recommending ISF2, which is
Okay. So let me just tell you something about probation's recommendation. With probation's recommendation, their policy, somebody can be missing for an entire year, and their policy now is they're not going to recommend. All right, they're not going to recommend revocation.
Okay, well, the reason I'm mentioning is not for that reason. It's for the fact that they're recommending ISF, which is a thinking pattern course. They're acknowledging that he needs help in thinking. I mean, the simplest thing is to report, for gosh sakes, and it's unfortunate that we're here on that issue in this case, because since his last MTR, he's been pretty clean. He did have one negative about a year and a half ago, but he's been pretty clean relative to a lot of those cases you've seen, I'm sure. And he's completed the parenting class. He has a job. And he tells me that the UPS job that he has requires drug testing because.
Why is he in custody?
He's in custody because he was trying to buy a car, and that's one of the problems he's having is transportation, getting here to report, taking a bus. It takes.
So what is his charge?
His charge is a fraudulent check and unauthorized use of a vehicle. So there was some kind of confusion about buying the car. He had the car. The check, I guess, was not, I'm not in that case. I don't know. But apparently there was a check involved, and it may or may not have been fraudulent. It's still pending, the allegation, but it's not a violent crime. It's not something, it's just stupidity, which is exactly what I'm saying.
And in the record, I'm not going to consider charges. I just wanted to know why he was there. I wanted to make sure it wasn't a warrant here or something of that nature.
Yeah. Yeah. I just wanted to show you that also he's been in jail over 500 days. In fact, just on this MTR, he got arrested at the end of April. It's been like 75 days he's been in jail in Uvalde. And when I talked to him on the phone over there, it sounds like a zoo over there. It's really not good. If you wanted punishment from my client, he's been punished, believe me. He hasn't been with his family. He's been in that literal zoo of a place. Horrible. He did time of 2.5 months already, 75 days. So he has been punished. He has a job waiting for him. UPS assures him that once he gets out of whatever he's in, that they have a place. They apparently liked his work, were happy. He passed the drug testing. So he has a lot of family support. Like I told you, his father's here. His other siblings and uncles are supporting him and his wife, and hopefully they can straighten him out. I know it's his third time, but I'm pointing to this thinking problem. If he was a normal person, we wouldn't be here. Obviously, you can't take him like he's like us. For us, it's ridiculous. I got that. But, you have to take him as he is, and he needs help. And that's why we're here asking for it. He's completed the parenting class that was required on his probation. You know, like he said, his wife is due any minute. I would like for him to be there for that. And as a counter offer, if the court doesn't like the idea of following the probation recommendation, and I can see why. But remember, he's done so much time that putting him into TDC, he'll probably get paroled out, you know, and I don't know, I would suggest maybe that you terminate him on SAT. Again, on this case, he's done lots of time. It's not like, you know, oh, he got away with something. He's been on probation almost 6 years. He's been in jail, you know, over a year. I mean, he's paid for the offense of unlawful carrying of a weapon. So just throwing yourself on my mercy to you that I assure you his family is really great and he is making progress. He's got the family, the children, the job, you know, and he told me that one of the problems he's behind in is pay. He hasn't made the fines, the payment due. He said because he had to pay to get off of the interlock, the device that monitored where he was. He had to pay like over $1,000.
All right, that has to be somewhere else because I always waive GPS fees.
Well, maybe.
Oh, you mean the ignition interlock?
Yeah.
You're talking.
No, ma'am. It was the GPS. You put me on GPS back in 2024, and I believe that time, I had to pay like $1,400.
Okay.
So he doesn't make much money. What do you do at UPS?
I'm a package handler.
All right, so let me just explain everybody where we are because number one, I realize that it's felon in possession of a weapon. We can say what we want to say about that, whether the laws are going to change, who knows? But the law is the law. So when he was first placed on probation out of this court in 2020, I ordered that he reside with his father. Then he had a motion to revoke, a violation of condition number 2. And I altered and amended his condition. I denied the motion. I altered and amended conditions to include a referral to felony drug court. If not accepted, then SATA. Then he came back in 2024 for a violation of condition number 5, which was failure to report. I denied the motion because he was like, I'm having a baby. Okay, great. I don't understand why people start having children when they have the instability of being on probation, but people do what they do. And he didn't report. So I altered and amended his conditions to include parenting classes and GPS for 180 days, partial for employment only. And his case was transferred to Uvalde because he wanted it transferred to Uvalde. Now we're back again. And what are we back for? He's not reporting. There's nothing else I can do with him. And as far as probation recommending ISF, ISF won't take him because he has pending charges out of Uvalde. So I'm going to grant the motion, find him guilty, revoke, and I'll sentence him to 3 years in the prison, give him credit for any time served. And counsel, I need you to sign a trial court certification. Mr. Gonzalez, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and electronically sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And Yaya, if he successfully completed any inpatient treatment that was, he should receive credit for that. Yes, ma'am. All right, thank you.
And can I get a chance to talk to you, David, or no?
Yes.
Can you put us back in the breakout room?
Yes, you can. And this is the wrong trial court certification, but I'll just add what I need to add to it. Yes, if you go in the back and they'll do it.
Thank you.
Alrighty, friends, about 20 minutes or so remaining of TCF Live for today. Let's go. We'll stay in Texas. We'll go back to Judge West.
Good morning. You're Lisa Pratt.
Good morning.
And this is 24 DCCR 1460. Ms. Pratt's charged with theft of property with previous convictions. And what's the announcement?
Your Honor, I believe we have a deal worked out. I would respectfully ask the court, depending on what the court wants to do. If you one more doctor's appointment, we can either plead today, and I would respectfully ask for sentencing without a PSI to be set, maybe 30 days, or we could reset it for a plea, but.
Oh, is the agreement for some kind of time?
12.
What I'd like to do while you're here is go ahead, we can do the plea
Yeah.
and I'll reset it without the pre-sentence report. And then we can set a sentencing date based around a typical time for a PSI is about 45 days. If that gives her time for that last appointment, we can do that.
Yes, sir.
Okay, I'll hold it while y'all take care of that paperwork.
Yes, sir.
Mr. Patterson? Mr. Patterson, you tested positive for THC. There's no reason you should have tested positive if you had stopped using before when you were in court last time. So obviously you're not doing what you're supposed to be doing with the drug patch and staying clean. So you give me no choice at this time but to raise your bond in your case. Let's see, what does it say that name? Current is set at $7,000 and give me a second to look at this. I'm going to raise your bond in your case to $25,000. Condition of that bond obviously is going to be that you have a drug patch on, but you can't, it's not just a matter of going and getting a drug patch. It's getting it changed every 2 weeks and it's the drug patch being negative and you staying negative. So if you make that bond, obviously you cannot use anything that has any type of THC that would test positive, legal or not legal. And you have to have the drug patch on within 24 hours of your release from custody. You can go back with the bailiff.
Well, I hope he enjoyed it because that got very expensive for him. Let's go across the hall, Judge Stevens.
I'm all right.
My last month in the Army, I changed.
All right, 26 CR 293. Who's the state on this one?
I will be good.
Leslie for me. Yes. Okay, you can work from there. Then you're charged with a 3rd-degree felony of failing to comply with sex offender registration. Do you understand this? What was the offer on this?
The offer was 10 years, and I believe that he's an habitual offender.
Twice. He's been an habitual offender status 2 convictions ago. So you're looking at, if convicted, no less than 25 years in prison up to life. Do you understand?
Yes, sir.
All right. And do you understand 10 years is less than 25 to life?
Yes, sir.
Okay. You thought about this, and what do you want to do?
Trial, I guess.
Go, this is your life statement. Go to trial, I guess.
I talked to my family, I don't want to take my plea.
Huh?
I don't want to take my family over then, so.
They're running your show? You don't have independent thought? I mean, it's you're the one that goes to prison, not the family, right? Okay, all right. Are they working with you or against you? Do you know?
With me.
Okay, all right. All right, so here's, you're not eligible for probation. We're gonna place this quickly, all right?
Yes, sir.
And this is your last shot at this, but I don't accept anything after the next minute. You've thought about it, this is what you're going to do, right? Then that's your destiny. No deal. We will place it first. When can we set this? Can you be ready in 6 weeks?
Yeah, that's fine.
All right, we're going to try this in 6 weeks. That's that one.
I can do anything in 6 weeks. Yeah, no problem.
Bryant Will.
Yes, Judge, he's here. Mr. Williams, come on up.
Are you Bryant Williams?
Yes, sir.
Okay.
Yes, sir. This is Mr. Williams.
Where'd the probation office go? Oh, there he is. Okay. Langston, you're representing Mr. Williams here. And Mr. Williams, you're charged with the second-degree felony of robbery. You're looking at up to 20 years in prison. You understand? Yes, you have to speak out so she can hear you. Just help us. Okay, good. You're kind of soft voice. Okay. What are we doing on this?
Hey, Judge,
What are we doing on this one, Mike?
what I was hoping, I'm sorry. What I
I'm looking at the probable cause. Yeah, I always have to read this stuff.
just what I was
But
hoping.
we got an issue here, right?
No, and I'm hoping that we can resolve it today. If Mr. Laird is still in a good mood on dismissals. Look.
Where's his
I'm
father?
hoping. No, the fault. Come on up, Mr. Williams.
Is that what you want to do?
I'm
Bring him up?
hoping so.
But he's the victim here, right?
Well, that's his dad. That's Mr. Calvin.
Yeah.
Williams.
Yeah.
And then obviously this is my client,
That's why
Brian
we,
Williams.
when we get a familial situation here, we want to walk through this
But just
deliberately and carefully because there's always a good reason that a family member is generally a family member is a complainant and ask for the police to come out, investigate and move forward because of the harm that occurs. But
Mr. Calvin Williams to my right, my client's biological dad.
And the victim in this case, according to the indictment.
He's informing me, but he also told me he wanted to inform you and the DA's office himself that he did not want to pursue any charges against his son.
Why?
And
I can't believe the DA's office has moved forward without talking to the victim. That's not normally what they do. They never talk to you.
No, sir. And sir, if I can,
Hold on just a second. Let me know.
Okay.
Let me read through this. Y'all called the police though, didn't you, for help, right?
And there's a officer gave,
Well, they put their lives.
Fitch put in his offense report that he asked the victim here if he wanted to proceed with the charges, and he said yes. At the time.
And that might have been at that time, but the
Well, I know,
dad is
but
adamant that he does not.
Everybody, but law enforcement gets put in harm's way. It costs a lot of ton of money for the taxpayers. And if you call for help and ask and say you want to prosecute it, you're not the guy making, after that, it's out of your hands. It becomes in the DA's office hands, really. And they're the ones that make decision because y'all called for help.
Yes,
and
sir.
y'all wanted something done and they did it. But you don't decide what the ultimate resolvement is. It's important. The DA's office always likes to have input, but people just can't call for help and get somebody arrested and then say, now, until next time, I just don't want him, we're not going to prosecute him. We'll see what happens next time. They are the decision makers, the executive branch of government. That's what happens. I mean, people want to hear the victim's input, but it's not fair to everybody. And I'm a taxpayer too. I just pay part of that cost. It's costing somebody, and you just can't later come back and say, okay, I don't want to prosecute anymore. Somebody else can write a check for all the costs involved, and then we'll see what happens next time. When you call for help, you're pretty much committed. And it's out of your hands. And you need to, shouldn't be treating your father this way. I mean, this is biblical. You don't treat your father and commit assaults. Shame on you. Really. If you were younger, you would be getting a spanking, because this is childish actions, sir.
And Judge, just to add on about Mr. Williams, yes, he did make that statement the day of, but just to give you some background on Mr. Williams, I'm talking about the dad.
Yeah, I'm sure he's fine.
No, right.
I think I recognize him.
Right.
Somewhere.
Well, I was going to tell you.
And I know another Calvin Williams who's a very special friend of mine.
But this particular one, Judge, he is a retired U.S. Marine, and he's also a mechanical engineer. So as far as his mind and his capacity, he's had great time to think about and reflect. And he reached
better than that. No, he knows the rules, and he took an oath when he became a Marine. He took an oath.
Right.
And he knows, he's got discipline in his mind, I'm sure.
Right. And he's a mechanical engineer by trade as well. But he specifically reached out to my office, and he came to me telling me that he did not want to go forward with this.
I know, but he said he wanted to at the beginning.
Right. I got you. So
So what it's like changing your mind at the altar.
Right.
I mean, it can happen, but it doesn't.
Right.
It's not kosher.
But what I told him was, I think it would be best for him to come here and tell that to you and the DA's office, and then
Here's the problem, though. Yeah, it's going to be the executive branch, not me. And you open the door for one, you can open the door for everybody. Theoretically, you allow this, we wouldn't have anything to do. One person after another can walk up and say, I've changed my mind now. He got in trouble. He learned his lesson. Well, we're not used as a tool for discipline. Well, we're used for something else, a procedure, a process that flows from you call for help, law enforcement goes and investigates it, then they turn it over to the prosecuting authority, the executive branch of government, and then they make the decision. It's out of the hands of the person who called for help. They called for help, and they don't have the prosecution decision authority. These people do. And that's the way it is. But what's good for one's good for everybody. And you start this, and everybody can come in and say, we thought about it now, I don't want him prosecuted. And what a waste of effort and time. I'd rather be doing something else than sitting up here and making this just something that's a farce. We have rules, and once it gets into the system, you really don't have a lot to say about it. These people have to say they're in control, but you ask for help and that's what initiates it. And then you got to follow through with it. But you open the door for one. What's fair is fair for everybody. And the next person is going to come up and say, I want the Bryant Williams rule. Then we have nothing to do, which may be a good thing, but still it's a waste of time and money. And we're talking about taxpayer money and time and effort of arresting him, locking him up, and people put in harm's way. But there's a system. And once the grand jury indicts, here's the indictment, they reviewed it and they followed through with everything, and they felt like there was probable cause here, that a second-degree felony, a crime that carries with it up to 20 years imprisonment. It's a crime of violence. Those are serious crimes. This isn't a parking ticket. This is something where it's a second-degree felony, which carries with it up to 20 years in prison. We just don't treat these things lightly, or else our jobs are worthless. But there's something to this. We've been doing this since 1787. Following the rules, holding people accountable when they commit crimes. Because we're supposed to live in peace. You commit crime, you have to pay, like everybody else does. And but people can't, but Mr. Williams is no longer in control of this, no matter what he says. I mean, he can say, I'm not going to be there. Then they can subpoena him, and he's got to follow a subpoena or he gets in trouble. Then he has to come up and sit and take the stand, and they're going to ask him questions, and he has to answer under oath. And we know what his answers are going to be unless he falsified statements to the police, which I don't think he did. So he would be, I mean, this is the way it works. It's a system of rules. This breaks the rule down. But anyway, so we're just set it for trial, I guess.
That's fine.
Until something else gets done.
Yes, sir. That's fine.
It will be set for trial, and that's what will happen.
I can't speak for you.
All right, Don, what can you do this way? Brittany Cormier.
Right here.
What are you gonna do with Brittany?
We do not need to bring her out. I'm gonna be filing a motion for mental examinations.
Judge, will we have a guilt test?
Yeah.
All right, let's head back across the hall for Judge West. We'll take one or two there and then end the day.
Good morning. Are you Ebrianna Bell?
Yes, Laura.
And Ms. Bell was previously in court, entered a plea of guilty to theft of property with previous convictions. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir, we have.
Any additions or corrections?
No, Your Honor.
All right, Ms. Bell. How old are you?
25.
You're 25 and you're already adding up some history that started as a juvenile. I'm going to go along with this agreement. And I really, really hope that you use this as an opportunity to do better for yourself and to break the cycle of what's been going on with you and your family. Looks like from what I can tell, everybody in your family's been to prison or in trouble. And so you can at some point continue doing all of that stuff and end up like that, or you can say, I'm going to do something different with my life. And that's going to be up to you at this point at your age, right?
Yes, ma'am.
It's not fair that things happen the way they did, but you're an adult. And so you can make those decisions for yourself at this point, right?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, follow the agreement that you made and find you guilty of theft of property with previous convictions. Sentence you to a term in accordance with your agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 3 years. You're ordered to pay the $500 fine as well as the $221 in restitution. And actually what I'm going to do today is I'm going to reduce that fine to $250. I want you to succeed. And I don't want the money to be the issue. I want that restitution paid off first.
Yes,
Okay. I want you to get a job and I want you to pay that off as quickly as you can and then do everything else that you're supposed to on probation. If you do everything you're supposed to, then for all practical purposes, your case here in court's over and you'll be able to serve that 2-year sentence while you're out on probation.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you'll be brought back into court. your probation revoked, and you'll be facing that 2-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimmler. So if you'll just have a seat here in the courtroom, probation's going to call you up to her desk to go over your paperwork. Okay, good luck to you.
Thank you, Your Honor.
Alrighty, friends, that will do it for this morning, but you will be able to see me and Michael Groff tonight on In the Blind with Mike and Dan. That is at 7 p.m. Eastern, 4 p.m. Pacific. There's been links dropped in the chat for it so you can find it, and we're linked here on the channel as well. And Ashley just put a link, so there you go. So head over there after this and set a reminder for yourself. It is not courtroom content, but it is a lot of fun, so do please join us for that. And be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. The wisdom I leave you with today comes from Eleanor Roosevelt. You gain strength, courage, and confidence by every experience in which you really stop to look fear in the face. I think that is quite true. Go have yourselves a great day, friends. We'll see you soon. Take care. God bless.